Item for withdrawal. Number 47.
Yes.
May I please, Your Lordship? I'm appearing on behalf of SC Biswas. As per the instruction of our client, we don't want to press this matter.
Okay. Ms. So-and-so, learned counsel appearing on behalf of Mr. S. Biswas, learned conducting counsel for the accused. This matter is since disposed of on withdrawal.
Promotional. Item 1.
May I please, my lord? It is a charge-sheeted matter, my lord, and offences under FOXO Act, my lord.
POCSO.
So, my lord, may I kindly call for the trial court record?
Where the, in which court the matter is pending now?
Before the Honorable Court of Special Judge, Hosai, my lord.
Ojai. Okay. Scan copy of the record from the learned trial court and also notice to the informant through the office of the public prosecutor, Gauhati High Court. When?
25th August.
Obliged, my lord.
25th August.
Item 2.
May I please, your lordship? Lordship, this is a regular bail application. Lordship will find the FIR at page number 19. Lordship, the allegation against me is that I was arrested with 29 kgs of ganja. Lordship, this is a charge-sheeted matter. Lordship, I humbly pray that at this stage, the record may be called for, Lordship.
Okay. Recessal call for the scan copy of the record from which court?
Lordship, a special photo of honorable special judge, special judge EPS, Kamrup Metro.
Kamrup Metro.
Lordship.
Okay. When?
On 26th August.
26.
I'm obliged, Lordship.
Item 3.
May I please, Lordship? Lordship, FIR may be seen as page 13, Lordship. Here what happened, Lordship? One group raid a business establishment, Mirror Fan Salon, namely Mirror.
Come up on 17, your lordship, similar matter has been faced, 17-8 matter.
CD is called for?
Lordship, in this case,
In this case, one, my lord, PA 2255, my lord. The CD fixed for on, my lord, 17.
Okay.
Lordship,
Okay.
Lordship, in this case, Lordship, notice under section 35 was not served, Lordship, and the seizure was.
Okay, on that day, we'll consider it. We'll peruse the case diary and also consider your submission. Recessal list this matter on
17,
17, right?
along with BA
Along with
number
BA
22,
number
20, 225526.
2255 and on that day CD which has been called for in connection with the BA number so and so will be perused to dispose of the present application also.
Published.
Lordship, FIR will find Lordship page 10, Lordship, in this case. Lordship already dealt with one matter, Lordship. Lordship already disposed. May I place this order, Lordship? Other
When?
Lordship, AB number 1732, Lordship. Lordship already granted bail, Lordship, interim bail, anticipated bail, Lordship.
But in this matter we perhaps peruse the case diary.
Lordship. May I pray, Lordship, at this stage, Lordship, interim may be granted, Lordship, and
No, we will peruse the case diary.
Lordship,
CD
initially,
on,
Lordship, this.
is the CD available with the office of the PP?
On 5-8, today we are, what's it?
13.
13, 7, 8.
Lordship may take at 2, Lordship, if CD is there, Lordship.
Can it be taken up with someone?
At 2, Lordship, in the meantime, Lordship, they can verify, Lordship, whether CD is there or not.
May not be available, my lord.
I will have to check whether my office.
At 2, Lordship.
Okay, after some time.
Lordship. Deeply, my Lordship.
Item 5.
May please, Lord.
Yes,
This petition is filed by the complainant himself for transfer of his complaint from Kasar to Guwahati.
Kasar to Gauhati.
Yes, sir. Because the difficulty faced by the applicant is that his son, he's not keeping well. Some childhood asthma and eye problem. And his petitioner is presently posted at Sonapur, and it is not possible for the petitioner to take him to on each and every day to Kasar. And the other thing is that he is a single parent of the child. His mother deserted the petitioner. So it is at this stage it is not difficult for the petitioner to carry the child and also leave him at Guwahati. Earlier the petitioner is at Bodorpur, but now due to his transfer, he enrolled his student child to the Half Point School at Guwahati.
The case was instituted by the wife.
It is a case between the petitioner and his brothers and some other person. They illegally encroached the part of the petitioner, and therefore they took away rupees 50,000 from his house also by encroaching into his house. Therefore, this case was filed, and this is not a case of husband-wife. It is a case between the petitioner, his brother, and third person.
Witnesses of these cases are from Kasar.
Yes, Lordship. The petitioner has to make the explanation of the witnesses, Lordship. That is true, but
We'll see, let notice go today.
Lordship, interim stay may be granted, Lordship, because the petitioner cannot take his child to the Kasar every time, Lordship. Because Lordship
We'll
has
consider
the
on next
connection-
date, let the other side appear. Heard, Mr. Sharma, learned counsel for the petitioner in this petition under section 407 of the 447 of the BNSS 2023 is preferred by petitioner, namely Bharat Barai, for transfer of CR case number 64 of 2025 pending before the Court of Learned Additional Chief Judicial Magistrate Kasar Silsor to the Court of Learned Chief Judicial Magistrate Kamrup Metro Guwahati. Mr. Sharma, learned counsel for the petitioner, submits that the petitioner is working in BSF
Yes, Lordship.
and he is posted at Sonapur in the district of Kamrup M, and that who instituted the case at Kasar,
The petitioner himself, Lordship.
and that the petitioner has instituted one CR case number 64 of 2025 against the respondent herein, and the said case is pending before the Court of Learned Additional Chief Judicial Magistrate Kasar Silsor, and that
Cases at appearance stage.
the case is in the appearance stage, and the petitioner is deserted by his wife, and as such he has the burden to look after his minor son, and it is not possible on his part to take his minor son to Kasar Silsor on each and every date, and under such circumstances, Mr. Sharma has contended to transfer the aforementioned proceeding from the Court of Learned Additional Chief Judicial Magistrate Kasar to the Court of Chief Judicial Magistrate Kamrup M Guwahati, and that the petitioner is ready to bear the expenditure of the witnesses in the said case. The submission of Mr. Sharma needs further consideration. At this stage, notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. Interim period of the petitioner will be considered on next date. Registrar also call for the scanned copy of the record. on appearance of the other side.
Lordship, may I kindly, if the cases of the petitioner, therefore, if it is state the the opposite party shall not be heard, therefore my prayer is that the matter may be stayed till the respondent appears.
No.
Because then Lordship may see page 24,
Hmm.
the illness of the child, Lordship.
Hmm.
Childhood asthma
Next day,
requiring
next day
constant
we'll
follow-up.
consider.
Therefore,
Not today. Let the other side appear.
Lordship, some date may be fixed.
On 18 September,
Obliged.
item 6,
May I please, Your Lordship? Lordship, the lower court records were called for. See, what had happened is that in this case, an FIR was lodged by, the background of this case was that this incident occurred when there was a dispute between the cookies and the maities. The Lordship is aware that there is a dispute which started in the month of May. Thereafter, what had happened is that the applicant, the petitioner herein had gone on his official duty to Imphal Airport, and while he was returning, his house falls in the road of the Imphal Airport. While he was returning, he just stopped in, and there was some altercation because his house was vandalized the night before. For that, he had given an FIR as well. Now, what happened is that thereafter the investigation, all this investigation was entrusted to the CBI. Then CBI investigated and a detailed report was filed. Closure report was filed. But the closure report was not accepted by the magistrate.
Okay. Madam, this trial court record has been received.
Yes, Your Lordship. The respondent number 2, nobody is representing
Because
respondent number 2.
no notices were issued on the last occasion, notices may go, what I pray, Lordship, because if Lordship uses the FR report, it clearly says about that this is a thing which has happened at the behest of someone else. The victim herself says that there was no sexual assault or any other. No, let me just complete that. Respondent number 2 would come once notices are issued. Now,
Okay, let notice go today.
Lordship, the same in Lordship, because if the trial proceeds, then this petition becomes infructuous. Lordship may see Lordship may please to see the
No,
FR
we will hear the other side, the informant.
till
victim.
returnable date, Lordship. Till returnable date, if
No.
Lordship, if the trial proceeds, then the petition
No,
will be
this is
infructuous.
a serious allegation.
Lordship, the FR says if Lordship peruses the FR clearly
We'll
says.
say. Heard Mr. Das, learned counsel for the petitioner. Ms. Kumari, learned standing counsel for the CBI.
Lordship, one prayer, Lordship, because here they had the petitioner, there was a court of inquiry, internal court of inquiry by the CRPF. That internal court of inquiry, he was found not guilty. Page 37,
Maybe there is one judicial order
Lord.
taking cognizance.
Lordship. No, that judicial order.
And the judicial order was passed after considering the record.
Yes, Lordship. There is not, Lordship, what I'm saying, the contradiction, the FR was filed. Now, Lordship, what I'm saying, Lordship, is that let the other side come all, and they have also, there are material contradiction. What I pray, Lordship, is that at this stage, till returnable date, it may be, because, Lordship, if the trial proceeds, then
Sorry.
the case would be infructuous.
Why?
Lordship, I'll be appearing there. If they appear in there till the time, till returnable date.
No. How the matter would become infructuous if you enter appearance before the trial?
Lordship, I'll enter appearance.
Then
I'll enter appearance. If
how the
trial
matter would become infructuous?
No, the matter herein will become infructuous.
How?
Lordship, if trial proceeds tomorrow, and
Then-
if trial is proceeding now, why I'm praying
After the trial starts, is there any bar to quash this proceeding?
no, Lordship, there is no
Then-
bar.
then-
No, there is no bar, Lordship. But
Then-
he being Lordship, what I'm praying, the power under 482 these events, he being up where there is not the
No, Mr. Das, you see how the interim order is to be passed.
Lordship.
The parameters have been laid down in the Niharika infrastructure case.
Lordship, I'm not on this. What I'm
That-
prima facie, Lordship, what I'm praying,
So
Lordship.
do we ignore the parameters
No,
laid down by
I
Supreme
am
Court?
not on Lordship, what I'm praying is that there is a report of the CBI who is who has given a report saying that why they have filed a FR.
Kikolo line. Scan copy of the record has been received from the learned trial court, and it appears that notice is yet to be issued to the respondents. Accordingly, it is provided that notice be issued to the respondents returnable on cover except
2 weeks.
Lordship, we have filed today our reply. We have filed today our reply also. It has not yet come on record. Today they have received.
Okay. 2nd September. Step upon respondent number to be taken by speed post and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 since Ms. Komari entered appearance and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. Ms. Kumari also submits that the respondent number 1 has filed a reply, but the same has not been placed on record. Accordingly, it is provided that SSL lists the matter on copy when 2nd September, along with the reply furnished by the respondent number 1. Though Mr. Das, learned counsel for the petitioner, submits that till next returnable that the proceeding pending before the Court of Learned Chief Judicial Magistrate Kamrup M may be stayed. Yet, the said pair of the petitioner will be considered on appearance of the respondent number 2 on next date.
Deeply obliged.
Item 7.
May I please, your Lordship. Petitioner was paying for Zimma of the 15 number of cattle.
Did not yet proceed, madam.
Here in this case, Lordship, petitioner certificate holder, Lordship, and there is no any allegation in the FIR, Lordship, regarding the cruelty of the animal. Only allegation is that the cattle is
Mr. B. Islam, learned counsel for the petitioner, and Mr.
short date may
Borthakur, learned additional PP for the
cattle was seized on 15
Mr. Borthakur
15
submits
5,
that
Lordship.
he has not received the case diary and he pays for granting him some time to produce the same parallel, list the matter on.
Report also received
26 August.
26.
From where it will come? Borthakur.
From my lordship.
Borkola.
26 August. Item 9.
May I please, your Lordship? Lord, we have gone through the judgment of the Honorable Supreme Court, my Lord. In fact, the paragraph from paragraph 23 onwards, my Lord, paragraph 25 is relevant, my Lord. If my Lordship knows, my Lord, it has been clarified that in the interim, such vehicles or any property have been seized can be released, my Lord. So this judgment was delivered on 7th of January 2025.
Hmm.
And my Lord, the order impugned is, my Lord, of a recent date, my Lord. Dated 35/2026, my Lord. So, my Lord, this is in contravention of with the observation and the direction of the Honorable Apex Court. My Lord, I am drawing my Lordship's attention to page 61, paragraph 7, my Lord.
From
My lord.
whose possession the contraband substances were seized?
My Lord, it has been alleged that the allegation is as such, my Lord, that the vehicle had been used, my Lord, for the purpose of the transportation of the substances which
You
have.
are the owner of the vehicle.
Yes, my Lord, I am the owner, my Lord. I have annexed all these, my Lord, my registration cards and everything also, my Lord. And my Zimma petition had been partially allowed. The mobile phone and other, my Lord, seized article had been released, except the vehicle and the cash amount, my Lord, that had been rejected.
Hmm.
Just for a moment, my Lord, if I read the paragraph 7, it will clarify, my lord. Page 61, may I read, my lord? Considering that the seized psychotropic substances was found concealed in the seized truck, and also considering the fact that the seized truck belonged to the accused Sri Gurpreet Singh, and he is a prima facie charged with the commission of the offences under section so and so of the NDPS Act, the prayer for Jimma of the seized truck is rejected at this stage because the seized truck may be liable for confiscation, and also because the seized truck would be required during the trial of the case, as it would provide an adequate evidence because the truck was used to conceal the contraband. And my lord, accordingly, considering that there is likelihood that the seized case amount of rupees 44,000 so and so might be confiscated in this case, the prayer for Jimma of the seized case amount of rupees so and so is also rejected at this stage. So, my lord, if I may be allowed to draw my lordship's kind attention, my lord, to the relevant part of the law, my lord. The confiscation procedure, my lord, had been earmarked, my lord, in section 62 and 60.
That is there.
That is there, my lord. Now, my lord, maybe
On
please.
the other day, one judgment was referred.
Biswajit Dev versus State of Assam. This
Yes.
judgment, my lord.
29 and 31. His case falls under one of the task category, so Supreme Court has specifically restricted that case to the vehicle to be released.
My lord, may I read from, my lord, paragraph 23, my lord? Is at page paragraph 23, court's reasoning, no specific bar oblique restriction under the NDPS Act for release in the interim of any seized vehicle. Having heard the learned counsel for the parties and having examined the issue at hand, this court finds that the different courts have taken a divergent views with regard to the interim release of the connivances and during the pendency of the trial in the NDPS cases, while the courts in cases referred to by the learned counsel for the respondent state of Assam have not released the vehicle in the interim during NDPS trial, yet in so and so is been summed. In paragraph 24, the judgment of this court are confined to their facts or in the context of the expression owner and do not lay down any general proposition of law. Consequently, the issue would have to be examined on the first principles. Upon a reading of the NDPS Act, this court is of the view that the seized vehicle can be confiscated by the trial court only on conclusion of the trial when the accused is convicted or acquitted or discharged. Further, even where the court is of the view that the vehicle is liable for confiscation, it must given an opportunity of hearing to the person who may claim any right to the seized vehicle before passing an order of confiscation. However, the seized vehicle is not liable to confiscation if the owner of the seized vehicle can prove that the vehicle was used by the accused persons without the owner's knowledge or the connivance, and that he had taken all reasonable precaution against the such use of the seized vehicle by the accused person. This court is further of the opinion that there is no specific bar oblique restriction under the provision of the NDPS Act for return of any seized vehicle used for transporting narcotic drugs or psychotropic substances in the interim pending disposal of the criminal case. So, my lord, my situation, my lord,
You come to paragraph number 33.
my lord. Broadly speaking, there are four scenarios, my lord. Though para 33, my lord. Though seizure of the drugs oblique substances from connivances can take place in a number of situations, yet broadly speaking, there are four scenarios in which the drug or substances is seized from a so and so. Firstly, where the owner of the vehicle is the person from whom the possession of contraband oblique drugs oblique substances is recovered. Secondly, where the contraband is recovered from the possession of the agent or the owner, that is like the driver or cleaner hired by the owner. Thirdly, where the vehicle has been stolen by the accused and the contraband is recovered from the such stolen vehicle. Fourthly, where the contraband is seized or recovered from a third party occupant with or without consideration of the vehicle, without any allegation by the police, that the contraband was stored and transported in the vehicle with the owner's knowledge and connivance. In the first two scenarios, the owner of the vehicle and oblique or his agent would necessarily be arraigned as an accused. In the third and the fourth scenario, the owner of the vehicle and oblique or his agent would not be arraigned as an accused. This court is of the view that the criminal law has not to be applied in a vacuum but to the facts of each case. Consequently, it is only in the first two scenarios that the vehicle may not be released or superseded till this reverse burden of proof is discharged by the accused owner. However, in the third and the fourth scenarios where no allegation has been made in the charge sheet against the owner and oblique or his agent, the vehicle should normally be released in the interim on so and so, subject to the owners furnishing a bond that he would produce the vehicle as and when directed by the court and oblique or would pay the value of the vehicle as determined by the court on the date of the release If the court is finally of the opinion that the vehicle need to be confiscated. So, my lord, I am in this category, my lord, the third category owner. I am the owner, my lord, but it had been used without the knowledge, my lord, or the in such scenario. It will be proved in the trial, my lord.
Your case falls in the third category.
My lord, if I am may be permitted to read over again, my lord.
No.
However,
The third.
30.
So you are the owner of the vehicle.
I am the owner, my lord.
And the vehicle was seized from your possession.
No, not from my. It has not been, my lord. Search and seizure is there, my lord, and page 44, annex 2, my lord. Name and particulars
Then
of the
you are
yes,
also accused of the
accused in the case also, my lord.
accused in the case.
My lord, my lord.
Yes.
Case 44 from him.
From him, Gurpreet Singh is the owner, my lord. Gurpreet Singh to owner.
He was in the vehicle. Page number 44.
My lord, my lord.
Gurpreet Singh, 55 years.
No, I have annexed the seizure list, my lord. Annexed the seizure list. Owner, RC to registration.
So page number 44 is clear that it
No,
is
yes,
from
yes,
your
Lord. It is
possession.
clear that the name and designation from whom making the seizure, so and so. Name and particulars of the person from where seized. Gurpreet Singh and Kulvinder Singh. Two words there, my lord. But my lord, the seizure of the particles, total 4 number of brown color plastic packet containing jelly type substances suspected to be opium, so and so, which was kept concealed inside the cabin of the 16-wheeler Bharat Benz truck bearing registration number so and so.
Okay, Mr. Bhattakur, anything to submit?
Yes, but otherwise, well, that specifically, category 1, he accused, recovered and he is the owner of the vehicle. From that document, the vehicle cannot be recovered.
That what is this? The trial is pending now.
My lord.
Trial, my lord, evidences has not started yet as per my instruction, my lord. Though charge sheet, listen, no? Charge sheet has been filed, my lord. Not the paragraph which my lord, we have, my lord, I have relied paragraph 35.
Yes.
Lord, may I read again, my lord? Though the seizure of the drugs oblique substances from the connivances can take place in a number of situations, yet broadly speaking, there are 4 scenarios in which the drug or substances is seized from a so and so. Firstly, where the owner of the vehicle is the person from whom the possession of contraband oblique drugs oblique substances is recovered. Secondly, where the contraband is recovered from the possession of the agent of the owner. Now, my lord, here is admittedly from the Milord charge sheet or the Milord seizure list. It had been said it had been seized. Now, Milord, whether he is present with the vehicle or not, Milord, that is not clarified in this seizure search memo also, Milord. What was the exact scenario? And in the search sheet also, Milord. Milord, it had been used as a recovered in the Honorable Apex Court judgment, Milord. Search sheet, it will search sheet. Next one, disseminate. So, Milord, from the Milord first category, Milord, it is very difficult to understand that the seizure and recovery. That is, Milord, whether from the recovery and the seizure can be constituted into different manner or not, Milord. Milord, if I can be satisfied, my lordships, on this issue, Milord, with some.
No, why is satisfaction is required?
No, Milord, because search and seizure, Milord. Seizing means, Milord, it can be seized from anybody, Milord, and the recovery, if it is from my pocket, I may be, Milord, driving the vehicle also, Milord, at that relevant period of time. But, Milord, without, because two persons was there, Milord, Gurpreet Singh and Kulbinder Singh. Now, Milord, who was carrying the contraband, Milord?
No,
Admitted, Milord.
it was not recovered from their body or
Milord.
person. It was recovered from the vehicle.
Vehicle, Milord, vehicle. Now, section 62 and 63 is very clear, Milord. It is
Okay,
from the
we'll see. We'll pass the order.
mild.
Page 56 from the one minor here details of district and from the minor medical code. There is specifically there are two ways. Good to stick.
Okay, we'll see.
Mild. Oblige.
May I please, Your Lordship? Your Lordship, this is a revision petition. It came up from a conviction order, actually. There was
Jimba,
Your Honor.
NI Act.
Yes, Your Lordship. So, there was a monetary transaction, not denying the fact. Transaction had happened in this case. And the persons between whom transaction happened, they were friends, staying nearby each other.
Okay.
So,
Mister,
and
your name, please.
JP Gogoi.
Learned counsel for the petitioner, Mr. Porter, learned additional PP for the state respondent number 1. This revision petition under section 438 of the BNSS 2023 is directed against the judgment and order dated 18/9/2025 passed by the Learned Chief Judicial Magistrate Udalguri in NI Act case number 9 of 2025. And also the judgment and order dated 23rd of April 2026 passed by the Learned District and Session Judge by the Session Judge in CA number Criminal Appeal number 43 of 2025. It is to be noted here that by judgment and order dated 23rd April 2026, the Learned Session Judge has upheld the judgment and order dated 18/9/2025 passed by the Learned Chief Judicial Magistrate Udalguri in NI case number 9 of 2025. It is also to be noted here that by impugned judgment and order dated 18/9/2025, the Learned Chief Judicial Magistrate has convicted the petitioner herein under section 138 NI Act and sentenced him to suffer simple imprisonment for 1 year and also to pay a fine of ₹4 lakhs to be paid as compensation to the complainant, namely Toranga Mounto, with default stipulation. Peruse the petition and the documents placed on record and also peruse the impugned judgment and order dated 18/9/2025 passed by the learned Chief Judicial Magistrate, Udalguri in NI case number 9 of 2025, and also the judgment and order dated 23rd/4/2026 passed by the learned session judge in criminal appeal number 43 of 2025. Let notice be issued to the respondents returnable in 4 weeks. However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance and received notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Step upon respondent number 2 be taken by speed post and also by usual process within a week from today. Rest shall call for the records from the learned courts below. Is there any interim pair here?
Yes, your lordship, if there is, if can any interim be granted?
The
He is
learned
inside judicial
counsel for
custody.
the petitioner submits that since the revision petition, in the revision petition, the record has been called for and notice has been issued. Operation of the judgment and order dated 18/9/2025 passed by the learned Chief Judicial Magistrate, and the judgment and order dated 28/4/2026 passed by the learned Session Judge Udalguri may be stayed till disposal of the petition. Taking note of the submission of learned counsel for both the parties and also considering the given facts and circumstances on the record, the sentence so handed down by the learned Chief Judicial Magistrate in NI case number so and so since suspended till disposal of this. And also the judgment dated so and so affirmed by which the learned session judge has affirmed the sentence stands state till disposal of this petition. List after 4 weeks.
Item 12.
I think this is a joint petition, lordship, for watching a proceeding which is pending, lordship, in the court of special the South Vankasa, lordship. Lordship, this case arises out of the affair, case 12, lordship.
Is there any agreement between the parties?
Lordship, there is an affidavit,
Affidavit.
which I was directed to file order dated and 19/6/2026.
Who appeared for the respondent number 2?
No, lordship, respondent number 2 is the lordship is beneficiary, lordship. Here in the case, lordship, the victim herself joined in this petition, who is the wife of the present petitioner, lordship.
No. Who filed this petition? Filed this affidavit?
Yes, lordship, the petition number 2,
Who
Yes,
appeared for her?
lordship.
Who appeared on behalf of the informant? Respondent number 2?
No, lordship, for her, for him, lordship, it was not yet notice issued, I think, lordship.
Notice not issued.
Yes, lordship. So, lordship, for my interim period, last occasion, lordship, on 19/6, and direction was issued by the court to file an affidavit by petition number 3, lordship. And this affidavit I have already filed, lordship. Because they are, lordship, leading an heavy conjugal life, lordship, out of wedlock. One child was also born, lordship. Lordship, in a like situation, lordship, Honorable Supreme Court, lordship, I'm just relying on judgment. The appellant was convicted for the offences punishable under section 366 of the Indian Penal Code and section 6 of the Protection of the Children from Sexual Offences Act 2012, and the sentence to rigorous imprisonment. Lordship, paragraph number 2.
Mr. Ahmed,
Yes, lordship.
here notice is yet to be issued to the respondents.
Yes, definitely. But
Today let notice go.
Lordship, my humble submission, Lordship, let the proceeding may be state, Lordship.
No,
Because the
here
victim-
you see the proceeding is under section 16, no, 6 and 17 of the POCSO Act.
Yes, Lordship.
So,
Lordship, judgment of Deepak Nayak, Lordship, in POCSO cases, the victim should be, Lordship, represented. Here she herself in the petition. So, Lordship, this judgment,
let her appear.
no, Lordship,
Let her appear.
she already appeared.
When?
Victim, Lordship, she joined this petition.
No.
For me.
When she appeared.
No, Lordship, for me, Lordship, she joined this petition. I have jointly filed this petition.
You can appear both for the
Yes.
accused and also for the
Victim,
Victim.
yes, she is the wife of the present petition.
Maybe.
Person.
But how can you appear for both the accused and the victim?
No, Lordship, because they are the lady living in the same family, Lordship.
Maybe.
Yes.
Is it not unethical for you to represent both the parties?
No, Lordship, in a case where their marriage is not disputed, they are living, Lordship. She is not the victim, Lordship. Then
Anyway, let notice go today. Heard Mr. Ahmed, learned counsel for the petitioner, Mr. Bortako, learned additional PP for the state respondent. Yes.
Suppose victim and disputing on behalf of the victim. Now it is difficult for us whether in fact victim for this honorable court to identify whether he is the appearing. Otherwise, yes, he appeared on behalf of the victim. But it is better for him because this court can otherwise trial court although has no power for crossing. Let them appear.
no, Lordship.
Identify trial court can identify yes the victim whatever he is
Lordship, I fully agree to him. Lordship, kindly see, Lordship. Yes. 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 Lordship, kindly see page 28 on affidavit.
No, we'll see later on. Today, let notice go.
Yes.
Let notice be issued to the respondent. Returnable on.
Then Lordship, your Lordship may please to pass an order directing to represent the victim through another counsel.
No, today notice will go. We'll see through whom she enter appearance before this court. 26th of August. Step be taken upon respondent number 2 by speed post and also by usual process within a week of today.
Petitioner number 2 because no respondent here is the petitioner. Victim is petitioner number 2.
No, informant is the.
No, page number 3, the informant is there.
Yes, yes.
However, no formal notice is required to be issued to the respondent number 1 since Mr. Borthakur entered appearance in this notice. However, it's the requisite copy of the petition be furnished to him during the course of the day. SSL also call for the scanned copy of the record of special POCSO case number 212 of 2024 pending before the Court of Learned Special Judge South Salmara Mankasar, arising out of South Salmara PS case number 42 of 2023 under section 7, 10, 11 of the Prohibition of Child Marriage Act, read with section 6 and 17 of the POCSO Act. List according.
One date.
Correct.
Okay.
Please. This is a passing application also of the FIR, hard sheet and the entire proceeding. Lordship, the FIR is a page 18. And this is a matter where the informant has put allegation of 498A upon the husband and also the entire family members, including father, mother, brother, sister, everyone. Now, interestingly, Lordship, the informant has married twice before this marriage has been solemnized with the petitioner number 1. And after filing of this FIR also, after 1 month of the lodging of this FIR, she has again solemnized a marriage with another person just after filing this FIR after 1 month, Your Lordship, and without seeking divorce. Interestingly, Lordship, the allegation that has been given of physical assault, Lordship will find that in the charge sheet at page 46, 47, the relevant portion, Your Lordship, there is no any seizure of the medical reports, nothing, Your Lordship, to despite the serious allegation of physical assault, Your Lordship. And Lordship may also go through the FIR also. There is no as such the definition of cruelty of 498A as it goes, Your Lordship. The 498A definition for cruelty it says that any willful conduct which is of such a nature as is likely to drive the woman to commit suicide or to cause grave injury or danger to life, limb, or health of the woman, or harassment of the woman where such harassment is with a view to coercing her or any person related to her to meet any unlawful demand for any property or valuable security, or is on account of the failure by her or any person related to her to meet such demand. So in the FIR, Lordship, there is no demand of dowry. Dowry has been present in the allegation of dowry is there.
No,
Moreover,
there are
Lordship,
two
to
parts
drive-
in the definition of the same.
Lordship,
There are two parts in the definition of
yes,
the
Lordship,
offense.
two parts. A and B.
Hmm.
Both doesn't fall under the definition of cruelty in this matter, Your Lordship.
Why?
Because Your Lordship here says that she must any willful conduct which is such of nature
Hmm.
is likely to drive the woman to commit suicide or
Hmm.
to cause grave injury or
Hmm.
danger to life. Here, Lordship, she has not.
You come to page number 25
Yes,
of your petition,
yes, yes, Lordship.
the vernacular part.
Yes, Lordship. There is the allegation, Your Lordship, and
Hmm?
she has married now again after the lodging of the FIR
No,
without
no,
taking
you come
divorce.
to this page number 25.
Yes, Lordship.
What is there?
It has said about the giving some medicine to her, physical assault by the father and mother.
Hmm.
This is the allegation.
Then
that has-
you have also tried to set her ablaze
Yes.
by pouring kerosene.
That is the allegation. The Lordship, the sergeant has
Allegation.
nothing to say about it.
And
They-
what is to be looked into at the time of quashing of the petition? Sorry, in quashing petition for quashing the FIR,
The allegation, Your Lordship, has been as given by the,
can it be said that no prima facie case is made out against the present petitioners?
yes, from the FIR, the prima facie comes out, Your Lordship, but from the charge sheet, Your Lordship, charge sheet has nothing to say about it. It doesn't support the FIR, Your Lordship.
Hmm. Is the search sheet available on the record?
Yes, Lordship. Your Lordship may go to the charge sheet. I have annexed here in as annex 46 and 47.
Materials, what is the allegation which were made in the FIR manner?
Hmm.
That states of the statements of the witnesses, everything is not there in the search sheet. Only search sheet manner that is during course of investigation, statement. Name of the, all those details. Right now, in this petition, all important from the FIR. Clearly, none of the officers rightly pointed out, but those are being seriously misunderstood. In Lordship, they were trying to set a place her and thereafter, बताया कि जो रास्ता में पढ़ने हद तक उससे मारपीट को गुरुतर भावे आघातप्राप्त করে আর বাক কেরাসিন তেল ঢালি জ্বলাই দিবলৈ উদ্যোগ পথ মোৰ কিয় বাকৰ প্ৰতি আধা হাৰ ওয়াসিদুল statement of those evidence for আধা হাৰ ওয়াসিদুল ফসল those are eyewitnesses my report. So those eyewitnesses statement.
Okay, let notice go at this instance. Heard, Mr. Ahmed, learned counsel for the petitioner, Mr. Portaco, learned additional technique for the state respondent. Number 1. In this petition under section 528 of the BNSS 2023, the petitioner has tried for causing the PRC case number 818 of 2026 under section 498A, 34 IPC. Arising out of Rupuya PS case number 75 of 2024. Where is the petition and the documents placed on record? Let notice be issued to the respondent, returnable in 4 weeks. Step be taken upon respondent number 2 by speed post and also by usual process. Within a week from today. However, no formal notice is required to be issued to the respondent number one since Mr. Barthakur entered appearance and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Rest shall call for the record from the scanned copy of the record from the learned trial court. Interim pair of the petitioner will be considered on receipt of the record from the learned trial court and on appearance of the respondent number two on next date.
Objection.
Number 14.
May it
Yes,
please the Lordship.
yes.
My lord, page number 23 is the FIR,
Mm.
which, my lord, we are impugning, my lord.
Mm.
Page 23. Apparently, my lord, it discloses materials, my lord.
Mm.
There are materials regarding my lord, there were certain allegations.
Mm.
But my lord, I am before your lordship on the backdrop, my lord.
Mm.
It discloses materials, my lord, no doubt, my lord,
Mm.
that there were some assault and all these things.
Mm.
This is the allegation, my lord. I am only on to that point, my lord. This FIR was filed with Mela, my lord. Mela filed. Why that, my lord? Just I'll submit in 2 minutes, my lord. Page number 91
Mm.
is the FIR first in time, my lord, which was registered on the same day,
Mm.
but it is 27 of 2024. This is by me, my lord.
Page number
Page number 91, my lord.
91. Yes.
Yes, my lord. This is the, my lord, incident which happened.
Mm.
Anyway, these are matters of facts, my lord.
Mm.
Thereafter, my lord, kindly, my lord, will see that the impugn FIR is post. This is 28 to 27 of 2024,
Mm.
and the police that the impugn is 28 of 2024, subsequent to my FIR, but on the same day. Now, my lord, just one thing, my lord, at page number 39. Although this is subsequently, my lord,
Mm.
here, my lord, the actual fact, my lord, it is brought to the record by the said informant, my lord, Rakesh Sharma, at page 39.
Mm.
My lord, this plaint is filed by the informant, my lord,
Mm.
Rakesh Sharma, at page number 39.
Mm.
My lord will kindly see at this 2 and 3, 1 and 2, my lord,
Mm.
defendant are the son and wife of the petitioner respectively, my lord.
Mm.
My lord, here, my lord, it is admitted position of the particular that informant, my lord, at page number 41. And thereafter, my lord, at page number 42. This, my lord, there were certain arrangement between the informant and the family of the petitioners, my lord,
Mm.
in regard to certain parking of vehicles.
Mm.
And my lord will kindly see that this was for injunction, permanent injunction, not to park those vehicles. Allegations were there, my lord.
Mm.
It says, my lord, that wife of Sri Nageshwar Chaudhary and son of Sri Nageshwar Chaudhary, who is the present petitioner, my lord, they have broiler chicken carrier vehicles whose business is looked after by Sri Swaraj Chaudhary, defendant number 1.
Mm.
Now, my lord, after that, my lord will kindly see at page number 44.
No,
43.
Mr.
Yes.
Hazarika,
Yes,
you
yes,
see, this is
Yes,
the
my lord.
plaint of a civil case.
Yes. Yes, my
So
lord, but
what is it
but
has
my
to
lord,
do with the causing of the FIR?
yes, at that point, my lord,
Mm.
there was an arrangement that the honorable learned civil court also by way of an injunction allowed
Mm.
my family to park 2 cars on the particular plot of land.
Mm.
who is this, my lord, all the crux of the matter, all dispute arose from there. Now he doesn't want us to park there, my lord. He himself is a tenant. So, my lord, now when we are parking two vehicles, my lord, that point of time, this 91, my lord, assault happened to me. My lord, I have not exaggerated anything. I have said whatever it is there. That assault was by seizing, my gold chain was snatched, and there was assault, and also broken my spectacles. That much, my lord. And to counterblast that, my lord, this particular FIR at page 23, which is impugn, is filed, my lord. My lord, that part may be.
What is this? These cases are pending.
Yes, my lord, I am there at the stage of appearance. Appearance is
First
not
it's submitted.
complete. Yes,
First it's submitted.
yes.
Let notice go at this instead. Heard Mr. Hazarika, learned counsel for the petitioner, Mr. Borthakur, learned additional briefing for the state respondent. In this petition under section 528 of the BNSS 2023, the petitioner has filed for quashing the PRC case number 2387 of 2025 under section 294/323 of the 393 IPC. Under which provision the case was registered?
Registered under
It is
section
under IPC or under
IPC, my lord.
IPC?
Under section.
The case is after 2023.
Yes, my lord.
Then it ought to have been under BNS.
Yes. Charge sheet was, my lord, filed under section 294 and 323 IPC at page number, my lord, 24. Page 24, my lord.
Okay. IPC.
Section was under 294 and 323. Cognizance is also
Pending
taken under
before
that.
the Court of Learned Subdivisional. Cognizance is taken under.
Yes. Page number 35, my lord. Page number 35 under 249 and 323 of the IPC.
249?
249 and 323 of the IPC. At page number 35, my lord. Peruse the case record, cognizance of offense under 249, 323 of the IPC.
Borthakur?
Yes, my lord.
What is going on? Pending before the Court of Learned Subdivisional Judicial Magistrate, Certificate S, number 2, Kamrup M. Gauhati. Where is the petition and the documents? Place on record. The learned counsel for the petitioner submits that after investigation after completion of investigation, the IO has alleged charge sheet against the present petitioner before the Court of Learned Subdivisional Judicial Magistrate S, number 2, Kamrup M. Gauhati. And now the case is pending at the stage of appearance. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today.
My lord, may I point out one thing, my lord? My lord, page number 35, although it shows 249, it should have been 294 because charge sheet was under 294. 249 is altogether a different offense. Typical.
Let the record come.
Yes.
Rest is allowed. Call for the scanned copy of the record from the learned trial court. Fixing the matter on. Interim pair of the petitioner will be considered on next date.
My lord, I'm
On receipt of record from the learned trial.
deeply obliged, my lord.
Item 15.
May I please a question, ma'am? NI case instituted against me, my lord. Cognizance has been taken by page 27, my lord. Primarily, my lord, my contention is the jurisdiction part, my lord.
Jurisdiction.
Jurisdictions, my lord, local code offending 142, my lord. My lord can come straight on your page number 22, my lord.
Page number
22, my lord.
22.
The branch manager, Dimapur, where the check was presented, my lord. Page 23, ultimate line, my lord. The complainant deposited the 3 check presented to Dimapur, my lord. Continue to page 24. Dimapur, yes, branch Dimapur, my lord. And in paragraph 5 also, the three checks were deposited in Dimapur once again, my lord. And then thereafter, my lord, page 23, as far as jurisdiction concerned, my lord, in paragraph 9, in the second line, the cause of actions for filing this case constituted from this facts and circumstances.
Page number
25, my lord.
25.
The fourth line, my lord.
Paragraph number. Paragraph number.
9 paragraph, line number 4, my lord. That the
Okay.
cause of actions for filing this case constituted from the facts and circumstances stated above and on different dates as mentioned above, and that this learned court has got jurisdiction to take cognizance of the offences stated and try the same, my lord. My lord can come to page number 27 for a moment, my lord. That will make the position very clear, my lord, how the court has assumed jurisdiction, my lord. Total violation of 142, my lord. I will demonstrate. This is the cognizance, my lord. After perusal of the affidavit and the complainant, photocopies of the document as well as the content of the complaint petition, prima facie material to proceed against accused Sayyid Sahabuddin under section 138, my lord. The complainant filed by Miss Mumtaz, my lord, against me. Accordingly, cognizance is taken against accused Sharifuddin, my lord. This is a copy-paste order. There is no allegation against Sayyid Sahabuddin, and Sahabuddin is not in picture. My lord, I will demonstrate. Now, my lord, can come straight on your page once again, my lord. Why I am time and again referring this, the first part of the complaint petition, my lord. All things has happened in Dimapur, my lord. She has presented the 3 checks, my lord, in Dimapur, my lord. Only on this line, my lord, only one line she has stated in her petition that this court has jurisdiction, and accordingly, page 27, learned additional chief judicial magistrate has assumed jurisdictions in violation of 142, my lord. Local jurisdiction is clearly defined, and thereafter almost in all Supreme Court judgment, my lord. Local jurisdiction means as defined under 142B, my lord. The offences under section 38 shall inquired into and tried only by the court within whose local jurisdiction, my lord. Now, by this page 22, 23, and 24, the complainant has presented the case there in Dimapur, my lord. And then case is instituted against me in Karimganj, my lord, and the learned court has taken the cognizance, my lord. This is the part 1 of my submission, my lord. Second part, my lord can come, I'm troubling my lord, time and again, beside the jurisdiction part, page 15, my lord, can look into for once, my lord. This notice was issued by one learned advocate on 13/10/2025, my lord. In paragraph 1, she has stated her address is in Dimapur, my lord. And in paragraph 2, my lord, you approach my client's brother-in-law. In the first notice, my lord, brother-in-law. Here, there is no name, my lord, and I am not there. And then, my lord, under what circumstances that I have also intimated to the bank, my lord will find at page 31, translated copy will find, my lord, as page 30. I have intimated to the bank that this was a lost check, my lord, and bank had duly acknowledged this, my lord. Third part of successive presentation, my lord. As far as law is concerned, my lord, there is no restriction that check can be presented more than once, my lord. But once the notice is issued, my lord, she or he forfeit her rights for second successive presentation, my lord. Premchand is very clear, my lord. So my submissions will be, my lord, as far as page 20 and presentation to the main branch, her current account address, my lord, all Dimapur, my lord. Unfortunately, case was instituted at Karimganj, my lord, and cognizance has been taken against me, my lord. There is no, other requirement is also there, my lord. If my lord can, at this stage, my prayer will be, my lord, prima facie this has a violation of 142, my lord, local jurisdictions, clearly defined, my lord, local jurisdiction, and Sri Balaji also in paragraph 42, 43, and 44, my lord, there was a confusion created that if it is main branch, if any man can maintain two account, more than one accounts, my lord. Home branch, how it has been defined in the home branch, this is Balaji has been clearly confined in paragraph 43 and 48, my lord. But as far as local jurisdiction is concerned, my lord, he presented the checks in the Yes Bank account she maintained in Dimapur, my lord.
You are referring to section 142A.
142, my lord. The
Two.
offense under section 138
Hmm.
shall be inquired into and tried only by a court within whose local jurisdiction, my lord.
Hmm.
Two situations and explanation is there.
Hmm.
If the check is delivered for collection through an account, the branch of the bank where the payee or the holder in due course, as the case may be, maintain the accounts is situated, or if the check is presented for payment by a payee or holder in due course, otherwise through an account, the branch of the drawee bank where the drawer maintain the account is situated, my lord. Here, she categorically stated in her pleadings, my lord, that she maintained the account in Yes Bank, Dimapur, my lord. So local jurisdictions will come, my lord, Dimapur only, my lord. And this part, my lord, in the explanation also.
So, subsection 2B.
Yes,
Your
my
case
lord.
is covered by subsection 2B.
Yes, my lord. And this has been thereafter, my lord, in Joy Balaji case, my lord, if my lord can, yes, in Joy Balaji's case, my lord, the issue came where the presentation part, delivery part, and maintaining more than one accounts part. In that also, in Joy Balaji's case, my lord, 225 INC 1362, my lord, the jurisdiction of such cases has been encored by section 142 of within bracket 2, my lord, at the place where the branch of the bank in which the payee maintain an account is situated. The sketch below is explained the concept of delivery and payments, my lord. Here also it has been beautifully clarified, my lord. If I am maintaining an account with West Bank, Dimapur, my lord, and I am presented the check before the Yes Bank, Dimapur, my lord, and thereafter, my lord, I have issued notice and the cause of actions arise, my lord. Here, everything has happened in Dimapur, but case was instituted against me in Karimganj, my lord. Second technical, my lord, if my lord can give me another 30 seconds time, my lord. The first notice was issued by page 15, my lord. All stating everything Dimapur, my lord. I am not on legally enforceability part, my lord. Thereafter, my lord, straight away, my lord can come page 18, my lord. From Dimapur, they have traveled to Karimganj. Here, everything in the notice itself, page 19, my lord, presented the said check for encashment through the bank, Yes Bank, Dimapur, my lord. Paragraph 3.
And where you have issued the check?
Check, my lord. My position is, my lord, can
You have not issued the check.
I have not. There is an intimation to the bank by page 30 and 31, my lord, for stop payment, my lord. In subsequent notice, they got the bank endorsement saying that stop payment from the drawer, my lord. Page 30 and 31. that has been duly acknowledged by the bank where I maintain my account, my lord.
Mm.
And it was intimated on 303-10-25, my lord.
Mm.
Bank has received this, my lord. The second
Okay,
legal,
what are the judgments you have relied upon?
yes, my lord. Paragraph 45 and 48, Jaya Balaji, my lord. In regards to the second legal questions, my lord, after the issuance of first legal notice, my lord,
Mm.
whether subsequent notice is allowed as per law or not. This has been also clearly clarified by the Honorable Supreme Court in Vinod Sivappa case, my lord.
No, there is no dispute about it.
Page paragraph 45 and 48, my lord, the judgment
Okay.
that I have relied, my lord.
Okay. Whatever you please go through the decision referred by him. You appraise this court later on. We will pass the order here.
I'm deeply obliged, my lord. I'm deeply obliged. Next date, my lord, is 2/9, my lord. I have also
No,
given the
today we will pass the order.
I'm deeply obliged, my lord. I'm deeply obliged.
Item 16.
Wait, please, your lordship. Lordship, may I take you, lordship, the order, impugn order that is on page 24, lordship.
Mm.
Here, the present petitioner is the government servant, lordship. He is working in the Assam Battalion Force, lordship, presently posted at Meghalaya, lordship. What happened? He stood as a bailer for the two accused persons who were arrested in a NDPS case, lordship. That case, lordship, after getting bail, lordship, this present petitioner stood as a bailer and deposited. There is a direction to deposit, lordship, 4 lakhs, 2 lakhs each for the two petitioners, lordship. This is the order, lordship. Thereafter, what happened after release of the two accused, lordship? They never turn up to the court, lordship. Now, notice was issued initially warrant of available warrant of issue arrest issued against this present petitioner. Subsequently, lordship, NBW was issued. That order, lordship, will find on page 24, lordship. Because the petitioner, lordship, engaged one advocate, lordship, he is representing this petitioner, lordship. Thereafter, that advocate, lordship, leave the Gauhati and he is practicing at Karbi Anglong, lordship, not properly representing this present petitioner, lordship. For which, lordship, this petitioner in trouble, lordship, NBW was issued, lordship. He is ready to appear before the court, lordship. And in the meantime, lordship, one order, lordship, I found, lordship, yet the case number is not properly reflect this. The present petitioner, lordship, approached before this Honorable High Court for reducing the bail bond amount, lordship. That's the order, lordship. But the case number was not properly given in the order, lordship. May I pray, lordship, let the record may be called for in the meantime, lordship, the NBW kindly be stay, lordship, because situation is that, lordship.
No, the question is whether non-bailable warrant of arrest can be issued against the petitioner. No. Whether such a situation is contemplated in the erstwhile CRPC or present BNSS.
Yes, well, yes.
Can the question is can the
He is duty bound to otherwise,
if he fails to produce the accused before the court, then you have to proceed in accordance with law. Okay.
if he appeared before the trial court and by stating that yes, those are the accused at that point of time I took bail on behalf of them. Now, my lord, it is difficult for me to, my lord. I could not charge by it.
No, what is the procedure?
Regarding whether
Forfeiture, that is for 89 lordship.
I have to check my lord, the exact property of the
Okay, at 2 p.m. Totally at 2 p.m.
Highly obliged.
Otherwise, while he stood at bail on, he have to take consequences.
No.
Because the position of this present
Consequences,
petitioner is
the-
not as an accused, lordship.
He has to face the consequence, but is it the consequence?
Yes, sir.
Is it permissible?
Highly.
17.
May it please your lordship. 528 application lordship.
Yes.
Page 13 is the FL lordship. And the vernacular part is the page
Page number?
17. Vernacular part is at page 17. May I read lordship?
No, not necessary.
Lordship. So lordship, thereafter lordship, this affair has been culminated into charge sheet, and lordship would be pleased to find that we have translated page 29 lordship, page 29, and the allegation part is page 30 lordship. May I take your lordship to the page 30? May I read lordship?
Page number?
30 lordship. Translated part of the charge sheet.
Not necessary. Let notice go today.
Lordship. Lordship.
Let notice be issued today.
Yes, lordship. That is the
Heard Ms. Tisum, learned counsel for the petitioner, Mr. Barthakur, learned additional PP for the state respondent. This petition under section 528. BNS is 2023. The petitioner has applied for quashing of the criminal proceeding arising out of FIR dated 38/5/2023. FIR of Gauhati PS case number 224 of 2023 under section 376/493 IPC, corresponding to session case T2 172 of 2023, pending before the Court of Learned Additional District Additional Session Judge Gosaigaon at Kukurajar. Where is the petition and the documents? License record. Let notice be issued to the respondents returnable in 4 weeks. That be taken by speed post and also by usual process within a week from today. Registrar call for the scan copy of the record from the learned trial court. However, no formal notice is required to be issued to the respondent number 1 since Mr. Barthakur learned additional PP entered appearance and received notice. However, extra requisite copy of the petition is furnished to him during the course of the day. Registrar lays the matter after 4 weeks.
lordship. May please to fix a date, lordship, if possible.
Interim period of the petitioner will be considered on next returnable date on receipt of record from the learned trial court.
15 September. I'm obliged, highly obliged.
Okay.
May please. Let conducting counsel DA Kayum is out of station. Sorry, madam.
May I please your lordship?
Yes.
Lordship, the revision petition, your lordship, the impugn order is page number 16, your lordship. That is, your lordship, Kimma Pia has been allowed, your lordship, subject to furnishing of a bank guarantee, your lordship.
Yes.
So your lordship has advised me to file an additional affidavit bringing the insurance policy, your lordship. That I did, your lordship. That is at page number 25, your lordship. That is the insurance policy, lordship, and the value of the vehicle, your lordship, mentioned at page number 26, your lordship. That is 12,85,000, your lordship.
12 lakhs.
85,000, your lordship. That is
And
26.
what is the amount of bank guarantee the trial court has
10 lakhs, your
directed?
lordship. 10 lakhs, your lordship.
10 lakhs.
That is 16.
So what
your
wrong
lordship.
with the impugn order?
16, your lordship.
No. What wrong with the impugn order?
Your lordship, that impugn order, section 11, your lordship. Section 11, your lordship, the word used starting with may, your lordship. So, lordship, that is the discussion part is there, your lordship. That is not mandatory part, your lordship, that the magistrate or the learned magistrate have to impose that condition of bank guarantee, your lordship. That is one thing, your lordship. And other thing, your lordship, otherwise the other acts, your lordship, that is the state act, your lordship. The other acts, your lordship, regarding this BNSS and
No, we are not concerned with other acts.
lordship.
Kettle. Because it is in the Cattle Preservation Act where the bank guarantee, furnishing of bank guarantee is provided.
Lordship.
Section 11.
Section 11, your lordship.
11.5. So value of the vehicle as per insurance certificate is above 12 lakhs.
12 lakh 80.
The trial court has imposed directed to furnish you the bank guarantee of 10 lakhs.
Lordship.
So how the impugn order is illegal or arbitrary?
No, I'm not saying that because, your lordship, I'm not in a position to furnish that much of bank guarantee, your lordship. That is my part, your lordship. Otherwise, your lordship, that is my.
No, you can purchase a vehicle of worth rupees more than 12 lakhs. Then why cannot you furnish the bank guarantee of 10
That
lakhs?
is my commercial vehicle. That is my earning, your lordship. Because I'm using this vehicle for earning, your lordship, for commercial purpose, your lordship, to earn, your lordship, to maintain my home, your lordship.
No,
But your
madam,
lordship-
you see, you have to demonstrate from the record
Lordship,
that the impugn order is illegal
lordship,
or improper.
lordship.
You demonstrate it because we have to reduce, if we have to reduce the amount, then we have to set aside the impugn order.
Impugn order, lordship. So, no,
And unless you demonstrate illegality or impropriety on the
lordship.
part of the trial court, we cannot
But
set
that-
aside the same.
provisions is there, your lordship. That is right, your lordship.
Then-
That provisions is there, but my submission is, your lordship. If we read, your lordship, with due respect, your lordship, on receipt of the report, the judicial may said first class may, your lordship. That what been used, your lordship, may. So, lordship, that discussion part is there, your lordship. That is my submission, your lordship, with due
No,
respect,
that's
your
right.
lordship.
The question is, whenever the trial court has applied a discretion
Lordship.
and passed an order, this court sitting in revision cannot interfere with the same and substitute its own view with that of the learned trial court.
Lordship. Otherwise, your
That is
lordship-
the settled principle in respect of a revision petition.
Lordship. Otherwise, there is no such provision, your lordship, which bars that releasing of a vehicle in other conditions, your lordship. So other conditions are also there, your lordship. I am, lordship, ready, your lordship, to
No, you were challenging only that part.
that part, your lordship.
Yes.
That part, your lordship, the furnishing of a bank guarantee part, your lordship. I'm pleaded that thing also, your lordship. I'm not in a position to furnish that much of bank guarantee, your lordship. So looking at that aspect, and your lordship, this is the discussion part, your lordship, also there, your lordship, in the section itself, your lordship. Even your lordship has one judgment, your lordship has passed one order, your lordship, quashing that that impunity of this bank guarantee, your lordship. So, your lordship, there is no
When?
such. That is also there, your lordship. Lordship, if lordship kindly fix it after some time, lordship, let me print out, your lordship. That's judgment, your lordship.
Item 50.
Please, your lordship. Also, can it be taken after some time? One of my senior is appearing through BC.
Oh,
the Zoe Hussain is in a special council of ED.
pardon?
Special, wow, special council of ED. Becky. This is a matter lordship regarding cancellation of bail. So it's a typical matter lordship, there is a perverse order where 47 is for, they are saying that
Item 39 and 40. More orders.
But here, contacting counsel DA Kayum, he is not oil, kindly acknowledge next, kindly taken up next.
On
Kayum, Mr. DA Kayum contacting counsel,
when do you want?
next week,
Next week.
Next week.
But
Perfect.
Can it fix on Monday, not US, the chip test, I is pending or suspension of sentence. And in second item, lordship, it is the appeal against the.
Otherwise, the both matter is fixed for final hearing,
Okay. When he will be available?
Let's.
When?
Next week, any day,
Next week.
Next week.
Okay. As agreed by learned advocates of both the parties, this is the matter. On COVID, accepted. 24th of August. 24th of August.
Obligation.
Yeah, lordship, in the next item, lordship, this, the appellant is in jail, lordship, so some this impossible. Hello.
Item 41.
My lord, we have taken these steps, my lord, to these respondents. They are disturbing us, my lord, making some, my lord, suppressing material specs, their criminal petitions, they appeared, but now they have disturbing us murder case, my lord. They is informing us.
Mr. Borua, learned counsel for the application. Mr. Bortatu, learned additional PT for the state respondent number 1. Office note dated 10/8/2026 indicates that service report in respect of respondent number 2, 3, and 4 are awaited. List the matter after 1 week. Awaiting service report upon respondent number 2, 3, and 4.
Obligation.
Come in.
For bail hearings, 29.
may I please, your lordship?
Yes.
Lordship, the accused, my lordship, is a 18 years college student, my lordship. And it is an admitted case of love affair, my lordship. Kindly see, my lordship, the FIR, my lord, police report, my lordship, final report. Page 15, relevant portion. Page 16, my lord.
13 is the vernacular copy.
Yes, my lordship.
POXO is there.
My lord.
Mr. Singh is for respondent number 2.
Yes, madam.
Okay. You are appearing as amicus?
Yes, madam. That's a matter. Considering that, yes, we get the papers of the section, madam.
Okay. First, let him argue.
My lord.
It is provided that SSL lays the matter the first week of September. In the meantime, SSL call for the up-to-date scan copy of the record from the learned trial court.
My lord, there's a short date, my lordship. Tomorrow it will be recorded. My lord.
First week of September.
Highly obliged, my lordship.
30.
Target is completed.
Heard Mr. Hatimuria, learned counsel for the accused, and Mr. Goswami for the respondent number 1. Mr. Goswami apprised this court that service upon respondent number 2 is completed. But no one entered appearance on behalf of respondent number 2. In that way of the matter, Sajna name is nice. Ruby Gogoi. Ruby Gogoi. Is Ruby Gogoi is appointed as amicus to represent the respondent number 2. Registry shall reflect the name of the amicus in the cause list and also furnish the relevant papers to her well in advance and list the matter on
20 August.
Yes, Lordship.
31.
I said it like so. It's completed. Yes.
Service completed.
Yes.
Now,
Now, Lordship, kindly see the FIR at page 11.
No, today we will appoint amicus.
Amicus. Short date may be given, Milord. He is
Learned
around
counsel
90
for
days
the
in custody.
accused and Mr. Goswami for the respondent number 1. Additional PP for the state respondent number 1. Mr. Goswami on instruction submits that service upon respondent number 2 is completed, but no one entered appearance on behalf of the respondent number 2. And in that view of the matter, Ms. Madhurima Datta is appointed as amicus to represent the respondent number 2. Registry shall reflect the name of Srimati Datta in the cause list and also furnish the relevant case papers to her well in advance and list the matter on
24.
sorted 19th.
Developed. 90.
May I please, Your Lordship? Lordship, here in this case, my lord, accused is behind the bar for last, my lord, 120 days. Out of 5 accused, my lord, 3 accused already granted bail by the, my lord, additional session judge. In my case, my lord, what happened, my lord, in earlier occasion, my lord, I was making submission on the point of, my lord, deadlock period between 207 and 209 of CRPC, my lord. In this case, my lord, case is at, my lord, pre-committal stage and is in the SDJM, my lord. Case is not yet committed to the session court. My lord will decide the bail matter, but my lord, before that, my lord will take up the issue because this issue directly relates to this case, my lord. And for that reason only, my lord, we are suffering, my lord, pre-trial incarceration, my lord. Basically, my lord, allegation was of a theft of a cow, my lord. But surprisingly, my lord, some sections of cattle preservation they have put, my lord, and also cruelty act also is there, my lord. My lord, I prepared a my lord, draft, my lord, regarding these deadlocks period, my lord. And my lord will come to the flag mark part, my lord, the last part, conclusion remarks I have mentioned, my lord.
Oh, how long you were behind the bar? Pardon?
82 days, my lord.
82 days.
24, 5, 27.
Search sheet is submitted.
Submitted, my lord.
Case is not yet committed to the session court.
My lord, this issue is important because, my lord, in many occasions, my lord, we can see this situation, my lord. They do not, my lord, commit the case.
No,
They hold the record.
The question is, in this bail application, can we adjudicate on these issues?
My lord,
This is not a criminal petition.
my lord can take up these issues, my lord, because
How?
under bail itself, my lord, because, my lord, bail is still in the court of SDJM. And, my lord, the opinion of the magistrate is that, my lord, once the summon is served, under section 61 and the other co-accused will appear, thereafter only my lord, magistrate will commit the case to the session court. And problem arise here only, my lord.
In piecemeal manner, he cannot commit the case.
My lord, problem arise here because, my lord, for indefinite rule, various rulings are there, my lord. I have already prepared in the draft, my lord. I have already discussed all those, my lord, rulings. Problem is that, my
No,
lord,
not
for
necessary.
indefinite
Here,
period, they cannot hold the record, my lord, for indefinite period. There must be, my lord.
oh, that you have to file one criminal petition.
My lord can observe these issues in bail also, my lord.
How?
Because case is still in the
No, no.
pre-committal court,
No.
my lord.
Here only we will see whether you are entitled to bail or not.
Yes, my lord.
So, search sheet is submitted under section.
My lord.
3032.
One of the Assam Cattle Preservation Act, and along with mention of to animal act under section 11(1), small d.
What
13.
are the maximum punishment for these offenses?
13(1), this is up to 8 years.
8 years.
8 years. How many accused have been search sheeted?
All 5, my lord. 5 accused.
And how many of them entered appearance before the magistrate?
3, my lord.
3.
Not yet appeared, summon issued, my lord. Those 3 were, my lord, granted bail by the session court. So they are outside the, my lord, jail, my lord. And other 2 are in jail, my lord.
2 are in jail.
Yes.
This petition is for the
For
2
one,
accused.
for one only.
One.
Yes, co-accused, yes.
Okay, we will pass the order. Whatever.
But, my lord, one.
Is in custody for
82, no, 120 days.
No, 24.
24, 5 hours.
24, 5, no?
Twenty-four 5.
5. May, June, July, August. Yes, yes. 82.
Okay, we will pass the order.
This matter, my lord, your lordship, it was the case, no?
Yes.
Only question, lordship, can you see the FIR page 10, my lord?
Case diary was called for.
Yes.
When?
No, your lordship, last 2-3 days back, one other case was disposed of, arising out of the same FIR.
Okay. Okay, okay. Okay.
That's why CD was here in the office. One.
Okay.
Page 10, my lord.
Mm.
Your lordship will find informant total 4 and accused 27. Present petitioner, my lord, number 2 and 3, though their name is, my lord, written something else, but father's name is same, my lord. So 2 and 3 is your lordship now. And their cases, my lord, they were not at all present. They were outside in their sister's house, about 35 kilometers away. They are not no connected with this. Only their problem is that the residence is near the place of occurrence. Page 11.
So according to you, your name is not there in the FIR.
No, name are 2 and 3. Name father's name are there. That's why we are come here. Madam. Dimple Hazarika. In fact, he is your lordship will find Aflu Hazarika. Father's name same, madam. Father's name and get together.
There may be some other sons also of that
No,
Afras Hazarika. Afas Hazarika. Your name is not there.
No, we are not at all, they are also not there, madam. And our name, so far name is concerned, this name, not our name, father's name same, madam. So we have come, your lordship. Police is after us, madam. Police is, because
Okay.
father's name is same, so police is, my lord, after.
Okay, is there any material against them?
As per the injury report, injury was revealed that weapon plastic, one person is one for inspector, and another person is food and plant.
No, I am asking you whether there is any material against the present.
There are 30 to 40% are there present at the time of incident, but the specific allegation against not that person.
Not there.
Hafiz Ali, Dilpon Hazarika, son of Papa Hazarika, and Bhaijan Hazarika, son of Papa Hazarika, Morali.
And the name of the present petitioners are also not there in the FIR. And there is no material against them in the CD also.
Yes.
We'll pass the order.
Already, your lordship.
Yes, got it.
Assigning order.
Yes.
Huh? Already we have given.
Yes. Same order.
Well, named one name, the father's name same, madam. That's why police after us.
Item 33.
Obliged to.
May I please? Last occasion, scan copy was called for. That's content. As per the office, 4826. Steps, listen. Listen. Coffee.
Oh, whether you have taken a step upon respondent, number 2.
This is extra copy. Yeah, next. Itu copy di sana naik. Kag bisa. And I think a step is not
Taken. Okay.
So
Okay, we'll fix a short date, then you take a step. Heard Mr. Mondal, learned counsel for the accused, Mr. Sami for the respondent. Office note dated 11/8/2026 indicates that
True.
no step upon respondent number 2 has been taken. Mr. Mondal submits that he may be allowed to take step upon the respondent number 2. They are allowed to list the matter on. Step be taken through the office of the PP, Gauhati High Court. Okay.
Last product to Marisha.
Sort that.
24 hours.
Okay. On that day, Mr. Goswami shall produce the service report, having obtained the same from the officer in charge of jurisdictional PS. 24.
Develop list. Azilo.
Yes.
Honor, more than 100 days he is behind the bar, Your Honor.
And where is the service report? You have taken a step upon respondent number 2.
No.
Steps to the implement from section number 2.
Only allowance for that, Your Honor.
On the other day, there was a direction to take a step. Heard Ms. Devi, learned counsel for the accused, Mr. Goswami for the respondent. Learned counsel for the accused submits that she may be granted some time to take a step upon respondent number 2. Office note dated 11/8/2026 indicates that no step upon respondent number 2 has been taken by the learned counsel for the accused. The learned counsel for the accused submits that she may be granted some time to take step upon respondent number 2. Parallel step be taken within 2 working days from today through the registry, through the public prosecutor of Gauhati High Court. Returnable on copy.
27 hours.
Sorted.
Sorted. Only sorted, Your Honor. 17.
On 19 on.
19th of August.
But productivity is to remind of this, Your Lordship.
Case diary.
See, 100 days, how many days?
100 days, more than 100 days.
Probably. 100 days to disseminate for me.
Whether any search sheet is submitted
Yes,
on
yes, search
Submitted.
yes,
within 90 days.
yes, Lordship.
have
Investigation
no
also
information.
completed, search it has been also submitted.
Okay. Mr. Goswami, Learned Counsel. No, Learned Additional PP apprised this court that after completion of investigation, search sheet has been submitted. Being search sheet number
Yes, guys.
accordingly, it is provided that Regis shall call for the scanned copy of the record from the Learned Trial Court fixing the matter on 19 August. 19 August. You take a step today itself.
Item 51.
Please, Lordship.
Yes.
Search it, case, Lordship. I'm in judicial custody for 1 year, 27 days till today, Lordship. The allegation is under section 103, section 1, I think murder, Lordship. Lordship, out of
So
7.
your contention was that 48 notice was not given
Yes,
to you.
Lordship, Lordship.
That is
Yes, Lordship. 48 notice was not provided to us, Lordship. Not issued.
Mr. Bortakur, here you have received the case record or case diary.
Can you say?
48,
Have you gone through it?
48 not provided, Lordship, and
2 p.m. Okay, 2 p.m.
Lordship.
Let him go through the record.
Lordship.
52.
None appears for the petitioner on call. However, Mr. Bortakur learned additional PP for the state respondent present. It appears that on previous that is 11/8/2026 also the accused the accused remain unrepresented, and therefore it has been ordered that in the event of subsequent non-representation of the accused on next date, appropriate orders shall follow. Since today also the accused remain unrepresented, this court is inclined to dismiss this application for non-prosecution.
Item 53.
Please, Lordship. Petitioner behind the bar adjourned 39 days, Lordship. An allegation only against them that they tried to manage the police by offering 50,000, Lordship. Kindly see the page is the 10 is the FIR, Lordship. And
Case is registered under section
section 303A, Lordship.
303A.
303 subsection 2, 317 subsection 2 of BNS, read to section 11 subsection 1D of prohibition of cruelty to animal act, read to section 13 subsection 1 of the Assam Cattle Preservation Act. Lordship. But in this, there is no section is applicable against the present petition because the present petition number 1 gives sell the 9 number of cattle out of 19 number of cattle, Lordship. And one Zakir Ali, he is the owner of the said cattle, and he approached the Lanes GMC. Thereafter, Lanes GMC the granted Jim and Zakir also granted PRS bail by the court in place of this honorable Lordship. Only TCR is received, Lordship. TCR was called.
They were a middleman. I'm going to record of them. They were a middleman who sent by the owner of the cattle to manage the police. Given a bribe of 50,000 for releasing the vehicle and the cattle. The police arrested them. They put the petition out. And
So
owner of the cattle is Zakir.
if that was the search,
Lordship.
Then the case ought to have been registered under the prevention of
Yeah,
PC Act.
that is not succeeded, lordship.
Succeeded
On the same section.
11(1) of
Same, lordship.
So
Same.
how these offences will be made out against them?
No cases, madam. And the main accused lordship, Zakir is an interim PRS bail, lordship, and also the cattle also granted Zimma by the learned trial court, lordship. And
To Zakir Ali, right? And
yes.
the vehicle also then granted
And-
by the
and
4026 to the owner of the vehicle.
And page 19 is the lordship. This is a receipt, lordship. The seller name is Saiful Islam. This is a present petitioner. Father name of father and purchaser name Zakir Ali. He now filed out of 9 number of cattle, lordship. He only his tried to produce the said the said pass receipt, lordship, to police that he sell the said 9 number of
No. If allegation against AO is attempting to bribe the
lordship.
investigating officer, whether a separate FIR has been registered against him.
No, lordship.
No.
Till that, no. And no section 8 of also prevention of prevention of corruption act not add lordship in this case, lordship. And not succeeded. Same section in an FIR registered under section same subject and succeed also submit under same subject, which is not applicable in the present petition of recovery law. In 39 days beyond the bar already, lordship.
Okay, who will pass the order?
Much obliged.
Order number 38.
May I please, your lordship? This is anticipatory bail matter, lordship. The alleging section is 329 subsection 4 oblique 140 subsection 4 oblique 123 oblique 64 subsection 2 clause 1 of
What
BN.
is the allegation against you?
Yes, lordship. Lordship, FIR is page number 888. May I read it, lordship?
Not necessary. Did you receive?
It is required, it is not received, it is required, allegation is required.
She did not receive.
Did not.
Lordship, I am applying marriage with informant. Lordship, kindly see annexure C page 14. Application of acknowledgement.
This is application. Where is the certificate? Whether the marriage has been registered?
They have applied on 17/7/26.
And occurrence took place on 14/6/2026. No, 10/6/2026. CD has not been called for.
Lordship, kindly some protection making. Some protection making.
No, you see the charges against you. Your name is there in the FIR. And you have enclosed only the application for registration of marriage. No marriage certificate is enclosed.
Lordship, after 30 days, it is completed.
You produce the certificate on next date, we will see. Heard, Mr. Your name, please?
A Islam.
Learned counsel for the accused, for the applicant, and Mr. Goswami for the respondent. Mr. Goswami apprised this court that the though CD was called for white order dated 31st of July 2026, the CD has not yet been received. CD along with the medical report of the victim. And he pressed for granting him some time. They are allowed to list the matter on when.
24, 25.
24.
Oblige.
Item 54. And for
None appears for the petitioner on call. For the applicant on call, list the matter after a week. In the event of subsequent non-representation of the applicant, a put order shall follow. Mr. Goswami, learned counsel for learned additional PP apprised this court that CD has been received. CD will retain till fixed date.
next week. On $24. Items for admission 20 and 21.
Can copy of this.
Not received. Received. Okay.
May I please your lordship?
Yes.
My lord, I am appearing in item number 21. In 20, other counsel is there. He was there, but not now. He is newly tagged, my lord.
20. The name is shown in the corpus.
Yes.
Mr.
BJ Mukherjee,
Mukherjee is there.
item number 20.
Release date. Or BJ Mukherjee. Counsel for item number 20
is not there, my lord.
Maybe they cannot put for company.
Some other day.
My lord.
They're not there.
And my lord, in item number 21, that is my matter, your lordship, there is interim that may be continued.
So your petition is against the granting of maintenance.
Maintenance, my lord.
Okay.
The one is base trimming of chairs on the 490.
Framing of search. Okay. Heard Ms. S.S. Zia, learned counsel for the petitioner in item number 21. Ms. E. Bhuya, learned senior counsel come additional PP for the state respondent number 2. State respondent number 2. And item number 20, you take down. None appears for the petitioner on call. However, Ms. So-and-so.
She's there, my lord.
I am appearing for item 20, Lord.
Are you ready to argue the matter?
20.
Are you ready to argue the matter?
Lordship, both the matters are tagged together, Lordship. We need to look after item 21. The petition of item 21. For the petitioner or for the petition. The date may be fixed, Lordship. My senior will argue the matter on the next day.
Your senior is absent.
My senior is at Lex, Lordship.
Okay. Ms. R. Saha for the petitioner in petition number 20 of 2020. SSL list this matter, list these matters on cover
26th of August.
26 August.
Obvious.
Number 22.
May I please, your lordship?
Mm.
My lord, in this criminal petition, my lord, we have challenged the complaint as well as the entire proceeding, my lord, which had been initiated. Basically, my lord, this is a service matter, my lord. My lord, I had been retired as a teacher of a school, my lord. Now a third party, my lord, who has no nexus with my service, has behind me, my lord, troubling me with some fictitious and frivolous complaint, my lord, which even does not exist, that I have obtained the qualification from an institution, my lord, high madrasa, which never, my lord, exists, my lord, as per my information, and I do not have any nexus with the said institution. The department, my lord, has also thoroughly inquired and put the matter to an end. Now, my lord, due to this pendency of this criminal case, my lord, my pensionary benefits and other benefits, my lord, is now on a hold. So, my lord, as a compulsion now, I am before my lordships, my lord. My lord, this is completely a malicious and to, my lord, with the flavor of personal vendetta type of allegation, my lord, is there. So, my lord, some hearing is required, my lord, in this petition. I straight away I can draw my lordship's attention, my lord, to the page number 101 of my petition, my lord. My lord, even the same allegation had been inquired into by the police earlier also, and police filed a final report. Against that final report, my lord, a complaint had been made that this and that complaint had been treated as a CR case, my lord. And that CR case is now proceeding, my lord. And for that, my lord, may be pleased to find page number 101, my lord.
PCR has been arrived. There on the call. Already 4 witnesses have been examined. Altogether 9 witnesses are there. Benefits their cases against accused petitioner.
No, whether the witnesses are examined so far have implicated him.
Lordship may see the depositions of complainant, CW1.
Yes, yes, please. Yeah, then next for us. We'll take it on.
Mr. Bhuya, have you gone through the?
No, my lord, we do not have the opportunity to go through the witnesses because, my lord, during pendency of this petition, my lord, the proceeding is commencing, my lord. That's why, my lord, perhaps the witnesses are being deposed. My lord, if I can get a copy of this evidences, my lord, it will help to assist my lordships also, my lord.
No, you can go through the same in the court court itself.
My lord.
We'll provide the record to you.
Then, my lord, can fix it on some other day, my lord.
Some other date.
My lord. Because, my lord, the prima facie with the case which we have projected, my lord, is basically a certificate, my lord.
No, madam, these are witnesses who are examined for taking cognizance only.
No, it's evidence report.
Evidence report side is also like processing now. So I understand.
No, these statements are under 200 CRPC.
Yes.
200.
Yes, 200.
200 statement.
They have to look at someone's issues like they here. And cases at this stage of this. So my humble submission is this method. If they will take all this plea method, they didn't charge hearing in this method. Because the complaint also has to get some opportunity to prove this case. And since it is not at the case stage of my appearance also. EBC has already started. So only 1 or 2 days they have some paid on the
No, the problem is that he has not been receiving the pensionary benefits.
Yes.
No, he may file appropriate application for the appropriate forum. That is.
My lord,
preferred
my lord,
petition
if,
forum.
my lord, my learned friend is saying that I should go,
Both the
my
matters.
lord, and, no, my lord, I am not mixing up, because the writ petitions are also pending for my pensionary benefits, my lord.
Okay.
My humble submission before my lord is that when the very complaint is not maintainable, my lord, then if I can satisfy my lordships that this is a prosecution with, my lord, intent of malicious prosecution, my lord, with a personal vendetta. I know, my lord, that these are the 200 statement had been made. Now, whether this 200 statement is sufficient to, my lord, establish a institution which does not even exist, my lord, where there is no nexus with me, my lord. So that's why, my lord, if we can go through this statement, my lord, on the next date, we'll try to satisfy, my lord. If it
Okay.
is not, my lord, then we'll obviously face the trial.
Okay, you suggested that.
My lord, any date, my lord, as per convenience of my lordships, my lord, I am available. my lord.
Heard Mr. A.R. Bhuya, learned senior counsel, assisted by Mr. Learned counsel for the petitioner, Ms. P. Bhuya, learned senior counsel, come additional PP for the respondent number 1, and Mr. S. Das for respondent number 2. 2. Respondent number 2. List the matter for further consideration on second week of September.
My lord, the date may kindly be given, my lord. My lord. Oblige. My lord, my learned colleague may kindly may
Yes,
be
yes.
permitted to go through.
He can go to
Ten
the
minutes.
report, yes.
My lord. Oblige. me.
Okay, then at 2 p.m.
So item number 50, please, your video is off.
Next.
Item 23.
Wait, please, Your Lordship. The Lordship, the petitioner have filed this revision petition for the order against the order dated 27/8/2025. That is the ex parte order. So he was the respondent has submitted respondent and filed an missed case for maintenance, for her maintenance. Thereafter, he was represented. The petitioner was represented, and after he had submitted the written statement also. Thereafter, when he could not present due to some medical emergency, and after that, without hearing the other side, without depositing his evidence, or the learned trial court has passed the final order and granting a 8,000 rupees of monthly maintenance. So the petitioner had filed that expartification petition before the court below, that which was rejected, Lordship. Therefore, the petitioner.
Where is the impugned order?
Impugned order, Lordship, first is in page number, Lordship, 57, Lordship. 57, 27, 11, 2025.
Okay. Whether notice was issued in this matter?
Lordship, notice was issued and service was completed.
So other side never appeared.
Never appeared, Lordship. So my humble submission is, Lordship, just to vacate the ex parte order, and one chance may be given to the petitioner to try to face the trial before the court below, Lordship. So thereafter, I have filed an additional affidavit, Lordship, to bring the record on the medical documents which were submitted there.
The requirement of section 145 of BNSS 2023 is that you have to show good reason for vacating the ex parte order. So according to you, because of medical condition, you could not appear before the learned trial court.
Lordship.
But you have not enclosed any of the medical document.
Lordship, I have filed a medical certificate and along with the prescriptions, which was filed before the trial court to bring the record on that is filed by way of additional affidavit. Lordship.
When?
I was filed. It is on Lordship 11th of June. Lordship. Maybe on record, Lordship.
No. Okay, it is there. But what is the materials to show that you have furnished this document before the learned trial court?
So I have annexed the certification petition, the petition that is
Page number?
Page number 51, annexure 6, Lordship.
Page number 51, annexure 6. You have simply mentioned there as copy of medical certificate is prescription.
So Lordship, para number 3, Lordship. 52 page number, para number 3, Lordship. The absence of the respondent petition was neither intentional nor deliberate, but due to the genuine and unavoidable medical reasons, the respondent petitioner is enclosing the medical certificates.
What was the interim maintenance amount?
It was 3,000, Lordship.
3,000.
Lordship.
Okay, we will set aside the impugn order, but you have to pay 50% of the amount.
Lordship.
4,000 as interim maintenance till disposal of the
Lordship.
petition before the learned trial court.
Deeply obliged.
Promotion.
There. But I have received an instruction in this matter. Lordship, kindly pay this, madam. It will be. But this summary of material, the next page, and
The FIR part of this petition?
FIR, Lordship,
Yes, Your
page 22, madam.
Yes. Lordship has seen the instruction in respect of paragraph number 7 in the first page, paragraph number 7, 8, and 15 also. Kindly take note of that, my lord. Serial number 1, 2. Yes. Therefore, my humble submission is, this is a case, where the petitioner is required for investigation purpose. So lordship at this stage, at this stage, may not be and may not entered in this petition at this stage. They kindly see what the prayer is, for the purpose of investigation.
The other day, the question was raised as to whether this petition with this pair is maintainable or not.
Lord, I got 1 day time to have the instruction, and lordship knows, the present disturbance situation in Dhemaji. Today also, the officers are busy with 8 demonstrations or protests are there, at Dhemaji because of the recent Arunachal the incident. So if lordship requires that, lordship directs me to file a affidavit in the matter, detailed affidavit, I can do that. But in any case, I have received the instructions and it shows that sufficient materials are there for the purpose of investigation. At least lordship may not entertain this petition at this stage.
Regarding the prayer portion, I may submit, your lordship, that definitely after the Niharika case, the vague term such as no coercive action, the Honorable Supreme Court has directed that no such direction should be passed. That I am aware, Lord. But at 33.18 paragraph of the Niharika case, your lordship, it is stated specifically by the Honorable Court that when such situation arises where no coercive action or arrest should not be taken place, that kind of direction has to be passed by this Honorable High Court, then that should be followed by clarification and explanation. That much only. Here, what has happened, technically, your lordship, I cannot come for quashing of the FIR because I am not agreed by the contents of the FIR, number 1. Number 2, there is a bar for filing an anticipatory bail, your lordship. So in the Niharika case, Honorable Supreme Court has directed that instead of staying the quashing proceeding, the petitioner may be directed to go for anticipatory bail. But here I don't have the benefit. Your Lordship, to go for anticipated bail. I have already once filed and withdrawn it to file appropriate application, Your Lordship. This is my situation. So I cannot go for quashing, neither can I seek bail. At this stage, even though I have paid for quashing, I'm not specifically pressing for those who are no coercive action. Only at this stage, there are materials I am not aware, but since my learned friend has said that there are materials, there may be some materials against me, since he is submitting on the basis of some written instruction, Your Lordship. But at this stage, I may be directed to appear. That means that much only, Your Lordship. I may be directed to appear, and any arrest may be subject to any order passed by this honorable court. Without any specific order by this honorable court, I may not be arrested, since custodial interrogation, according to me, is not required. The allegations in the FIR summary is that extortion and certain local peoples have helped in that extortion. This much is the allegation, and 2 named accused were there, Your Lordship, which apparently belongs to the band outfit, Your Lordship. That now, under such situation, Your Lordship, I will cooperate with the investigation. So a direction at this stage will be sufficient till my learned files, keeping the maintainable issue also open, Your Lordship. Only I may be directed to appear before the investigating officer, and I must cooperate. And any arrest, custodial arrest, since it is not required, any arrest only after a direction from this honorable court. That much only, Your Lordship. Instead of those who are no coercive action.
You say interim order is passed when the FIR is challenged or any particular order of the trial court is challenged. Here, nothing is there.
Nothing is there. But I have already.
FIR.
Yes, Your
You are
Lordship.
not for passing the FIR.
No, I'm not for causing of the FIR. Because I don't have any grounds to.
Order of the court also, or any notice issued by the IO also.
Your Lordship, the only thing is that I may be, since my learned friend has submitted that there are materials against me, and for investigation, I'm required there. I'm willing to go there.
The problem is that judicial order cannot be passed in vacuum.
Lordship, since it is 226 application, that is why I'm.
Right, but parameters are there. How this interim pair can be granted?
Lordship, till he files the additional, affidavit in opposition, Your Lordship, the affidavit, detailed affidavit, Your Lordship, till then only. I may be directed to appear before the IO, and I may not be arrested without any order from this honorable court. That much only, Your Lordship.
Yes.
Well, in a case of this nature, Lordship has seen where the petitioner has a direct link with the co-accused during he has named him.
Yes.
That he has fired the three cartridges recovered. Those are fired by the petitioner. It is the statement of the co-accused who is arrested, who is in the custody.
No, where those cartridges were fired?
Kindly see, Malad. Yes, Malad. That is my Malad, para 1 of the first page.
That is not possible. I have not fired him. I have an armed license, but I have.
No, is there there is no averment in the FIR to that effect that someone has fired some cartridges?
These things have come up during investigation. During investigation, it came up because at that point of time, that was the starting point. The criminal proceeding started with that FIR. During investigation, these things have come up because kindly see the 3 cartridge cases covered during lawful search of his residence were actually fired by the petitioner. During search only it came up.
Where he had fired it?
The empty cartridge, those were recovered in the residence of Bidut.
No, mere recovery of empty cartridges, whether it amounts to an offense. Empty cartridges.
In fact, the detailed case diary will reveal. So since Lordship on 11th has directed us to have the instructions, and accordingly, these are the links and these are the materials. The vital materials are there in this case. Lordship has seen. If the petitioner, if in such a case, of this nature, the police is barred from the questioning the petitioner.
No, not questioning. Only custodial arrest. That too for a small period.
That he cannot have a privilege of that. Only by saying that I have no link. On what basis? Because After investigation, during the course of investigation, it has come out. So why someone has been issued to him? He's not responding. He's evading. And before the honorable court, he says that I have no involvement, and only on the basis of that, whether he can be protected, and the police can be restrained from the interrogating him.
Mr. Nath, you see, in the FIR, there is no statement against him.
No name, not name.
Then you have stated in the instruction that some empty cartridges were recovered. Where those cartridges were, the next question is from where it was recovered.
At the residence of
Then
Mr.
who used the same?
At the residence of Mr. Bidut Burhagohai, it shows,
Whether recovery of empty cartridges is an offense.
Empty cartridges, recovery of empty cartridges may not be as such, but when the entirety of the facts and the allegations under investigation comes, if Lordship considers, ultimately it has a link with that. Can you see the offense?
No. While serving the demand notice,
at this stage,
that someone has fired some cartridges or fired some rounds, then the matter would have been different. Yeah, what is the allegation? They served the demand notice.
But a demand notice was served. It was kindly see the date of FIR is on 27/3/2026 in the month of March. And during course of investigation, these things have come up. It was in the month of March, after 4 or 5 months, when the investigation has proceeded to an extent. Then the involvement of the petitioner came out.
You do one thing, you produce the case diary on Monday. Heard Mr. Sharma, learned counsel for the petitioner. Mr. Nath, learned senior government for the state responsibility. Person to order dated 11/8/2026. Mr. Nath has produced the instruction he is received from the Deputy Superintendent of Police. Advocate B. Devaji, IO of the case.
Logic.
Having produced the instruction, so produced before the court today. This court find it's necessary to produce the case date. And accordingly, Mr. Nath is directed to produce the case date before this court on Monday. Interim pair will be considered on that day.
Can it be on Tuesday, well, the 15 August is there, and because of the disturbing situation, I need 1 day more. Kindly give us 1 day more.
18, all right.
15th August is on Saturday, and the disturbance is going on in Dhamaji. The entire area is under.
Okay, Tuesday.
Tuesday. Logic. Logic.
May I say, can it be fixed at 2 year lordship?
Okay, 2 years.
Just one clarification, the original case diary or the scanned copy will do,
Original case diary.
Original. Logic.
Right.
Promotion.
May it please your lordship. My lord, yes, I have gone through the provisions, my lord, in this case. My lord, whether my lord NBW can be issued to the bailor, my lord, yes, not my lord. NBW cannot be issued to the bailor, my lord, because liability is financial liability. There is my lord, specific provision under which those forfeiture of bone, my lord, thereafter show cause notice and recovery of those, my lord, my lord, those financial, my lord, otherwise there is specific provision in 491, my lord, 491. So that has to be followed. My lord.
Heard Mr. B. So today, learned counsel.
Recovery of the penalty. My lord.
We got to learn this application in this petition under section 528 of the BNSS 2023, the petitioner has challenged the order dated 4/6/2026 hospital learned additional sessions as conducted in Gauhati in this case number 30 of 2019. Arising out of Gauhati GRP as case number 66 of 2019 under section 26. Is to be noted here that by impugn order dated 4/6/2026. Learned trial court has issued non-violent warrant of arrest against the presentation. It was already learned counsel for the petitioner submits that the petitioner stood as bailor to one of the accused of the ARPS case number 66 of 2013 under section 22C and this is extra 29 and DPS Act. Namely, what is the name of the accused?
Lordship, the accused name is, that is on FIR on page 4, Sangling Tuang and Jalal Piu. Lordship will find on page annexure 2, Lordship. Page 13 onwards, Lordship.
That is the FIR.
That is on page 14, Lordship. Type copy.
Where is the bail bond?
Bail bond, Lordship.
We have not enclosed.
Lordship, one copy has, Lordship, I have submitted, Lordship. Yes.
Stood bailor for two accused person, namely Xian Leon Tuan and Zaula Pu for rupees 2 lakhs each. 2 lakhs each. And that petitioner hearing is serving as
Lordship, Assam Battalion, Para 6 in page 6, Lordship, I have stated. Assam Rifle in Shillong, Mega, now posting at Shillong, Lordship.
is serving in Assam Rifle, now posted at Shillong. And on account of failing to produce the accused persons before the learned trial court. The learned trial court by order dated. When the non-bailable warrant of
That is on page 24, Lordship.
non-bailable warrant of arrest was issued against the present petitioner on 4/6/2026. So we submits that there is no provision in the BNSS 2023 for issuance of non-bailable warrant of arrest against a bailor for failing to produce the accused before the learned trial court. And section 490
1 of the
490,
BNSS,
one of the
earlier
BNSS
446 of CRPC.
provides for forfeiting of the bail bond.
Yes, Lordship. Procedure when bond has been forfeited.
Procedure for forfeiture of the bond. And section 492 of the 492 provides for cancellation of bond and bail bond. And without following the said procedure, the learned trial court has directly issued non-bailable warrant of arrest against the present petitioner, which is not at all permissible. The portable learned additional PG also fairly submits that there is no provision in the BNSS 2023 for issuance of non-bailable warrant of arrest against the bailor who failed to produce the accused person before for the court, concerned court. Concerned court. Having heard the submission of learned counsel about the parties of this court, carefully come to the petition and the specific record and also files and verdict 4/6/2020, given order dated 4/6/2026, by which the learned trial court has issued non-bailable warrant of arrest against the present petition. In view of absence of any provision in the BNSS 2023 for issuance of non-bailable warrant of arrest against the bailor, and also for not following the provision in section 491 and 492 of the BNSS 2023. This court is of the view that if in order dated 4/6/2026 fails to withstand the legal scrutiny and accordingly the same is then set aside in cost. However, the learned trial court is directed to proceed against the petitioner in accordance with the provision of section 491 and 492. This petition is a disposal and this news says.
Highly obliged. Obliged.
49.
I have found two judgment, one judgment of this honorable court, your lordship. Yes, I mark. Your lordship, my prayer is to modify the order, your lordship, not to cancel, your lordship. And if your lordship kindly come to page number 15, your lordship, that is the RC, your lordship, of this petitioner, your lordship, that vehicle been, though the value of the vehicle more than 12 lakh, your lordship, that has been financed by your lordship, SDB Financial Service Limited, your lordship.
Yes, whatever.
In view of the provision of Assam Cattle Preservation Act 11(5), there is no illegality in the order passed by the trial court. the trial court has, my lord, rightly, my lord, after applying his own discretion, my lord, that order, my lord, has been passed.
Nice to see. Okay. Siane. All of this on. Adjournment नहीं है इसमें आज के adjournment time specific matter है
Okay, let notice go at this is what to do.
Lordship, there is we have a specific peculiar case in this matter.
Pardon?
Because peculiar case in this matter. So the learned senior is supposed to appear, Lordship, here.
Maybe, but without hearing the other side, without.
Not because, Lordship, he is in jail, Lordship.
Pardon?
He is in jail still now.
Maybe, even then we have to issue notice.
Lordship, in for my say, as because the department is insisting for the special counsel to appear. Can it be on tomorrow, Lordship? What do you have to do?
No, morning, today morning.
Notice,
so the matter
notice,
was
notice,
fixed.
just saying notice. Notice, baby.
My lord, may I submit, my lord? I am appearing in the matter. Bail has been granted after, my lord, granting custody after remand on a ground that notice to a friend or a relative was not given, which is on the face of it contrary to the record. We have given notice to his nominated person, who is his neighbor, who is his family friend, which he himself gives in his statement before us. Please see that, my lord, only one page in the petition, page 98. The only ground for releasing him is that grounds of arrest has not been communicated to the friend, which is also incorrect. Please see, my lord, 98. Answer to question 7, my lord, may see. This is his own statement. Under section 50, please explain your relation with Manish Sharma. Manish Sharma is the friend. As per BNSS, you are required to intimate a friend or a relative. Relatives are absconding. So please see what he himself says, my lord. Manish Sharma, son of Kailash Chand Sharma, is my neighbor and we reside in the same building. Our families have shared a close and cordial relation for the last 3 to 4 years, and we have a family-like relation with each other. And please turn to, my lord, page 67.
So, notice was served upon Manish Sharma.
Grounds
the
of
friend
arrest
of the
supplied.
friend of the accused.
No. Page 67, my lord, may see.
Yes,
Please have page 67.
Notice was served on Manish Sharma.
Notice, grounds of arrest, everything given to both the accused and Manish Sharma.
Yes.
Please see, my lord, page 67.
So that's why I'm asking you that the notice was served upon Manish Sharma.
As well as the accused. Yes, my lord. Both of them. And please see, my lord, the requirement of law in BNSS, section 48 of BNSS, my lord.
Necessary, you show me the document by which the notice was served upon him.
Yes, please see page 67, my lord. Manish Sharma's signature saying received copy. '67, bottom left, my lord, may see.
Left.
My lord, has that received a copy, Manish Sharma. It is not disputed that Manish Sharma has been served. The trial court also proceeds on the basis that yes, Manish Sharma is served. Despite that, it proceeds to release him on bail. Now, my lord, may see one more page.
So
Page
where is the impugned order?
Yes, my lord, may see the impugned order at page 1. No. Yes.
45.
Relevant at, my lord.
Page 45. Lord.
Page 4, para C. The learned special judge says Manish Sharma is unknown to the accused, whereas the accused himself gives a statement that he's my neighbor, he's my family friend, he's my close family friend. Page 4, para C, my lord, may see. It is submitted on.
You tell me whether this annexure 10, the statement of Alok Zain, was before the learned trial court at the relevant point of time?
Yes, my lord.
Yes.
It was there. Yes, my
Record
lord.
was placed.
And that is noted by the learned trial judge, my lord.
Where it is noted?
Please see page 4, para C, my lord. It refuses to. It is submitted on behalf of the prosecution side that one Manish Sharma was informed about the arrest of the accused in terms of section 48 of BNSS, and the intimation letter has been mentioned to be intimation of arrest. Although it is disputed that the said Manish Sharma is unknown to the accused, nor the accused has nominated him to receive notice of intimation of arrest, it is submitted on behalf of the prosecution that accused has instructed to serve notice of his arrest upon the said Manish Sharma. The section 48 makes it mandatory that police officer or other person making an arrest shall forthwith give information regarding such arrest and place where the arrested person is held. A bare perusal of the said intimation of arrest fails to indicate that either Manish Sharma or anyone of the family of the accused was intimated. Whereas, my lord, admittedly he was intimated. The only question was whether Manish Sharma is a person known to him. Now, my lord, may see section 48, the language is clear.
No. My point of query is whether this annexure 10 was produced before the learned trial court?
Yes, my lord. Yes, it is produced. It is produced. I must point out why, my lord. Because
on what basis
it is
you were
part
submitting
of.
that it was produced?
Yes, my lord. On instructions, I say it is produced. My learned colleague will also confirm.
Yes,
my lord.
I have produced. I myself was present. I have produced all the records pertaining to.
Whether this annexure 10 was produced
Yes,
before
it
the trial
has
court?
been gone through, Lord. So I myself was present during the proceedings as a SPP there in the.
How it was produced before the court?
All the records were. I have produced all the records. On the records, it was there. I have shown it also. The section 50.
I have just received, my lord. I have just received instruction from the IO also. Annexure 10 was produced before the learned special judge. In original, my lord. And I must point out one more reason why it was produced. Because it is bearing the signature of the accused also. Please see, my lord, annexure 10, bottom. Every page bears the signature of the arrestee. Page 54 onwards, my lord, may see.
When section 50 was specifically produced, Lordship, they were being asked as bail petition was moved, my Lordship. So we are being asked to produce the case diary with the investigation record, Lordship. We have produced it in original to the special judge, Lordship. Mentioning the section 50 also, where he has.
The case diary available with you now?
Now, case diary is available. Case diary is available.
This is, my lord, what we have placed on record is a copy of this very case file, my lord.
Yes, Lordship, maybe, Lordship.
Yes, Lordship. This is
The original case date.
original.
Okay, we'll pass the order.
My lord, I'm requesting for a interim relief because he's still in custody. He is in
Okay,
custody in the predicate offense, my lord.
All right, we will see the case diary. And
I'm
if we
praying for a stay
satisfy
of
that,
this order.
order will be passed.
Please, my lord, I'm praying for a stay of the order. There is no violation, my lord.
Okay, we'll
We have,
see.
we have, we have served the copy of grounds of arrest to the accused also, my lord.
Okay. Next.
Leave your life.
Highly obliged, Lordship. Highly obliged, Lordship.
Bhattacharya, you have gone through the record.
Yes, my lord, I have gone through the record, my lord.
Whether that notice was served.
My lord, first page of the record, my lord, there is an order dated 19/7/25. 47 notice served, 48 notice was served through, my lord, WT message, my lord.
48 was served through.
WT message, that is there in the record, my lord. 19 order dated 19/7/25, my lord. 47 served, 48 served through WT message.
Page number.
No, my lord, that is not in the petition, in the record, my lord. The order of the trial court, my lord.
Which part of the order it is reflected?
Yes, my lord. Your lordship may kindly first, on the day of the, my lord, production, my lord, this production, or he was arrested on 18/7. Thereafter, order dated 19/7. That is, my lord, first, second,
Where it is mentioned that notice under section 48 is served.
not some issued, my lord. Issued, no, sorry, my lord, issued on through WT message, my lord. That is, my lord, on 19/7.
No, where it is mentioned.
Move the option approach. PCR to duty.
What is this? The case is pending now.
Lordship, it was an evidence state process.
Evidence state.
Yes, Lordship. Out of 17, Lordship, 6 witnesses have been examined. Lordship. The informant has also been
And
examined.
earlier also you have filed the application, bail application.
Not before this court, Lordship.
No,
There is
before
first
the trial
application.
court also
Before trial was filed, also it was rejected.
rejected.
Yes, Lordship.
Whether you have taken such ground before the trial court at the earliest point of time.
No. Lordship, now the long incarceration I have taken here first. Lordship.
No, how prejudice is caused to you?
Lordship, 48 was not served, Lordship,
Because
so one time
you
I
have
have not,
already been informed
physically not
and you
received.
have applied for bail also.
Yes, Lordship. No, on the date of remand, Lordship, I have not applied. So
Subsequently also you have
immediately I have not received, Lordship. Physical not received, there is no in the record.
Test is how prejudice is caused to you. If you show that prejudice is caused to you,
Yes.
only then this would amount to violation of the provision.
Yes, Lordship. Another grounds also in 47 also the grounds of arrest were not mentioned, Lordship. In
47 is mentioned in the order sheet itself.
No, Lordship, 47, sir, grounds were not mentioned, Lordship. There is no grounds of arrest, Lordship.
My lord, only WT message sent to the family of the accused, my lord. 47. That is, but although my lord, my lord, numerically 48 is not there, but WT message sent to the family of the accused, served to the family of the accused.
Technically, nothing in the record, Lordship. I have not received the 48 list. That's for instruction, Lordship.
And my lord, in this regard, regarding my lord, whether he has earlier taken all these ground before the trial court, I would like to point out before your lordship, my lord. Here, my lord, on 22/7/25, my lord, he was represented by his counsels, my lord. His bail petition, my lord, rejected. Thereafter, on 21/5/26, my lord, he was represented by his counsel, my lord.
Where is that document?
I have, my lord, flag mark, my lord, those orders, my lord. 22/7/25, 21/5/26, thereafter, my lord, 2/7/26, thereafter again on 16/7/26, and all those bail petitions were dismissed on merits, my lord. At that point of time, he never, my lord, takes all these grounds, my lord. And now, my lord, for the first time for this honorable court, my lord.
My petition paragraph 13, I have made statements that I rejected by the trial court. There is a statement.
And whether he can take all these grounds, my lord. In this regard, my lord, I would like to point out one recent decision of the Supreme Court, paragraph 12 and 14, my lord. Yes, my lord. Yes. 12, my lord, may I read, my lord? Paragraph 12, my lord. With respect to the contention of the learned senior counsel for the respondent that there is no waiver of the right granted under Article 22(1) of the Constitution of India, and therefore the stage at which a plea touching upon fundamental rights is raised would not matter. We would only clarify that when an accused person files bail application, the stage might become irrelevant. However, this is important, however, when the accused person warranted a finding on merits on the earlier occasions, it is not open for her to go back and raise the plea on the issue pertaining to the grounds of arrest thereafter.
So I want to place one order, is an order passed by the Honorable Chief Justice of our High Court.
And here, my lord, in this case regarding merit, the accused person, my lord, himself, my lord, he killed his own wife. Regarding that one eyewitness, his own son, my lord.
Not on the merit lawsuit,
Yes.
6. Last page lawsuit, para 38.
And paragraph 14 also, my lord, we are conscious of the fact that bail is the rule and jail is the exception. Presumption of innocence ensured to every accused. However, we are dealing with a specific case where the earlier orders rejecting the bail applications of the respondents on merits have attained finality and the trial has already begun. So at no point of time, all these grounds were taken by the accused earlier.
Okay, last para 38 lawsuit. However, in cases where the breach of the requirement is accompanied by other violations, such as illegal detention or infringement of
That's all right. You say, there is another decision of Supreme Court in state of Karnataka versus State Dorson.
Yes, my lord. There is also, my lord, regarding
2025 SSC online SC
Yes,
1702. There also Supreme Court states that
paragraph 20.17, my lord, regarding
section 14 of the BNSS is mandatory. The courts apply a prejudice-oriented test when examining the alleged non-compliance or procedural lapse. Here, technical non-compliance or irregularity does not automatically render the arrest illegal or entitle the accused to bail unless it is unless it results in demonstrable prejudice or denial of fair opportunity to defend.
Also, 1 year, 27 days in custody. Long incarceration is also there. Long incarceration.
Incarceration, that's all right. When he was arrested,
18/7/2025.
18/7/2025.
Long incarceration also, Shravan Kumar is very clear. I will appear before the trial court regularly, Lordship. I was working as a station master.
You have taken the that plea in your petition,
Lordship.
which paragraph?
Regarding long incarceration. Was paragraph 10, page 8 of my petition. Last time. Yes.
So here one thing the court has to say whether there is any lapse on the part of the prosecution in production of the witnesses before the trial court.
There is no lapses, Lordship. I am not on the married, Lordship. Out of Lordship, 17/6 have been examined, Lordship. The informant has already been examined, Lordship. So, Lordship, I will appear before the trial
Up to
court.
the merit of the case, then
Regarding long incarceration, Lordship, I have
37 of the NDPS Act also.
Yes, there is otherwise no lapses on the part of the investigation. 37 is not applicable in my case, Lordship. It's a case of murder 103, Lordship.
Okay.
Yes, Lordship, it's a 103 case.
Not under NDPS.
Yes, not NDPS, Lordship. That's why I'm praying this. Regarding long incarceration, I have less one order of export, Lordship. Para 2, taking into consideration the fact that the petitioner is reported to be in custody since so and so and has suffered that so and so incarceration reason for over 1 year 6 months, and there being no likelihood of completion of trial in the near future, which fact cannot be controverted by the learned counsel appearing for the state, we are inclined to grant him bail.
Here, how many witnesses have been cited?
Here 17.
Out of 17, how many witnesses examined?
Out of 17, Lordship.
Total 6 witnesses examined, my lord, till 14/7/26.
Out of 17, 6 examined. Lordship.
Till 14/7/26, he annexed, my lord, deposition of 5 witnesses.
Imposing any conditions, Lordship. I will face the trial, Lordship.
Maybe you see the person is from Bihar.
Lordship. But I am an employee of railway, Lordship. I am a station master. I was working at that time. I was working as a station master.
Okay, we'll see.
Imposing any condition, Lordship. Bibliography.
24.
Please, your lordship. Lordship, the impugned order is page number 60, lordship. Here in this case, lordship, is an NI Act matter, lordship. The prayer of the respondent
under section 143A for interim compensation of 20% lordship had been rejected by the learned trial court. After that, lordship, I aggrieved that order. The respondent preferred a criminal revision petition before the learned session judge, and learned session judge has set aside the order of the learned trial court and directed the present petitioners to pay the 20% interim compensation to the opposite party. The present petitioner is before your lordship against that order, lordship. So, lordship, can we have it appreciate the page number 58, lordship? What happened, lord?
So, where is the impugned order? Page number?
Page number 60, lordship.
60.
60. Lordship, in this case, lordship, when the respondent filed the petition under section 143A, the learned magistrate kept the petition abeyance and take the evidence of the complainant first. And after cross-examination of the respondent, the petition for 143A was rejected because, lordship, the respondent has failed to establish a prima facie case on certain grounds. First grounds, lordship, that check, the two check.
Where is that order?
That order is page number 58, lordship. The relevant portion is from the bottom part. 58. May I read, lordship, from the bottom part? I have also perused the case record thoroughly, and upon such perusal, it transpires that no case for exercise of discretionary power to grant interim compensation to the complainant is made out at this stage for the following reasons. Number one, lordship, the accused has taken a plausible defense during the stage of offense explanation, wherein they had categorically stated that they had borrowed an amount rupees 6 lakhs and not rupees 15 lakhs from the complainant, out of which they claim to have returned 1,40,000, and that before they could return the balance amount, the complainant encashed the security checks handed by the accused persons. Next, number two, lordship, the complainant during his cross-examination admitted that the exhibits 5 and 6, that is two checks, lordship, 5 and 6, were given to him by the accused person as security checks which were undated. That is admitted in the cross-examination. The complainant during his cross-examination also deposed that the said two checks were with him even before issuance of legal notice to the accused persons. The defense has also raised question on the point of condonation of delay, as the complainant had prayed for condoning delay of only 2 days and not 7 days. Lordship, here what happened, lordship? Can you have appreciate page number delay page number 21, lordship. 21, lordship. Para number 12. Para number 12, lordship. That is the complaint petition filed by the respondent. Lordship, here stated that the complainant begs to state that the demand notice dated 23/6/22 was received by the accused person on 24/6/22. And when 15 days time is added, it comes to 9/7/22. And subsequent 30 days ends on 10/8/22, lordship. However, the instant complaint could not be filed by the complainant within stipulated period of 30 days. And in the event 2 days delay been caused, preferring the instant petition. Lordship, in the complaint petition itself, the respondent prayed to condone the delay of 2 days. In fact, lordship, the 30 days ended on 10 August 22. If it is 10 August 22, lordship, kindly appreciate page number 25, lordship. The case has been filed on 16th of August. Page number 25, lordship. That affidavit. Last line, lordship. 16th of August, this case was filed. And 30 days ended on 10th of August, Lordship. And 6 days delay definitely there. That was also put in the cross-examination. But they paid for delay of 2 days. And accordingly, the learned trial court condoned the delay 2 days. But remaining 4 days, delay is still there. That has not been condoned, Lordship. And Lordship, furthermore, if your Lordship kindly appreciate page number 18, Lordship. What happened, Lordship? Before dishonor the check, the notice, earlier one notice was issued to the petitioner before dishonor the check that if you not pay the amount, I will deposit this check to the bank. I have given you 45 days, which is not permitted in NI Act, Lordship. That before dishonor of check, notice cannot be issued. That is in page number 18, para number 4, Lordship, of the complaint petition. It is an admitted fact. Para number 4, page number 18, Lordship. Thereafter, when the accused persons did not return the borrowed amount, even after repeated requests, the complainant through his counsel sent one legal notice dated 1/4/22 to both the accused person demanding them to repay the borrowed amount 15 lakhs within 45 days from the receipt of the said legal notice dated 1/4/22. By the said legal notice dated 1/4/22, the accused person were told that they had issued check in term with the said agreement dated so and so, and the complainant shall be at liberty to deposit the check if they fail to repay the borrowed amount. That is before dishonor, Lordship. And after dishonor, there is a delay of 4 days still there.
Okay, now come to the impugned order.
Yes, Lordship. The impugned order, Lordship, has not appreciated this these anomalies I have already submitted before your Lordship.
Is 69 para 15.
Para number 15, Lordship, you will see the para number 15, page number 69.
Yes.
The impugned order says that so far as point of delay in filing complaint is concerned, in the impugned order, nothing is mentioned by the learned trial court as to what is the basis on the respondent accused persons are claiming that there are 7 days delay in filing the complaint. Merely making an averment without any basis is meaningless. Moreover, if the learned trial court was the view that there might be delay of 7 days, learned trial court must have decided said point first, or must have specifically observed that the point requires evidence, and as such, the same would be taken up after evidence. I do not find any merit on the said reason given by the learned trial court, more particularly when trial was commenced and there is no basis of taking such place. Lordship, it is a fact itself in the petition that there is a delay, and same has not been condoned. As per affidavit, Lordship, case was filed on 16 August. And statutory period over on 10 August. And prayer of delay only 2 days. In fact, the delay was 7 days. And in this respect, Lordship, the Rakesh Ranjan Srivastava is very much clear, Lordship. There are some parameters framed by Honorable Supreme Court that before entertaining the petition under section 143A NI, there are certain parameters, Lordship. Rakesh Ranjan.
So according to you, no prima facie case could be demonstrated by the petitioner, no, by the complainant before the learned trial court,
Lordship,
for which the trial court has rejected the pair.
rejected the prayer. And also, Lordship,
Hmm.
in the cross examination, some other contradictions are also there that also been mentioned in the order by the learned trial court. That check was undated and check was, where is the 58 page number?
And the learned additional session judge has not considered the aforesaid points.
Aforesaid points, Lordship. Because Lordship, in the Rakesh Ranjan Srivastava, it is clearly says that if the accused make a pleasable defense, then 143 should not be allowed. Pleasable defense. And it is discretion power, Lordship, not mandatory. And quantum of the compensation is also discretionary, Lordship. That judgment I have produced, I know that judgment is available with Lordship. And another judgment I placed before Lordship, that is S. Nagesh versus Shobha Aradha, that is in 2026 judgment, Lordship. Where the learned apex court, I have already submitted, Lordship. S. Nagesh versus Shobha S. Aradha, para number 14, Lordship. Where it is same case, it was, Lordship. In this case, Lordship, 2 days delay was there, but that delay was subsequently condoned after taking the cognizance. But the case was set aside and quashed by the Honorable Supreme Court. Says that, Lordship, para number 14. It is manifest from the clear and unambiguous language of the above proviso that the power conferred upon the court to take cognizance of a belated complaint is subject to the complainant first satisfying the court that he had sufficient cause for not making the complaint within time. The satisfaction in that regard resulting in condemnation of the delay must therefore precede the act of taking cognizance. Ordinarily, a proceeding institute with limitation linked delay before a court of law does not actually figure as a regular matter on its file until the delay is condoned. Until the delay is condoned, Lordship, the case, even the cognizance has taken, that is not in accordance with law, Lordship. In paragraph number 15, finally, Lordship, on the above analysis, we have no hesitation in holding that the learned magistrate erred in taking cognizance of the respondent complaint under section 138 of NI Act, even before the delay of 2 days in its presentation was condoned. The order passed by the High Court refusing to quash the same is satisfied. Here is a clear-cut case, Lordship. The 4 days delay is still there. Their prayer is only 2 days. And learned trial court records cognizance order shows that 2 days delay condoned. But 4 days still remain. That's my humble submission.
Yes.
May it please your lordship. First of all, lordship, my learned friend has pointed out that 2 days delay was already condoned, lordship, while the cognizance was taken out, lordship. That order was not put to challenge, Lordship. Whether they are permitted to raise that issue again, Lordship, in this petition.
No, this is a law point, they can raise the same.
That order was not challenged. Lordship, that order was not challenged.
Maybe.
That order set in finality, Lordship. There was no challenge to that order, Lordship. Delay was condoned. It has to be challenged, Lordship.
No,
So far, my understanding, Lordship.
calculation is wrongly made then.
Lordship, the delay period was condoned and thereafter, Lordship, the cognizance was taken. Those orders were not taken before any appellate forum, Lordship. Then we have filed this petition under section 143 and trial court rejected, Lordship. That order was put to challenge by the complainant before the additional session judge, and additional session judge has taken into consideration all aspects, Lordship. Page 69, your Lordship may kindly see. Paragraph 15, so far as point of delay in filing complaint is concerned, in the impugned order, nothing is mentioned by learned trial court as to what is the basis on which the respondents, accused persons are claiming that there are 7 days delay in filing the complaint. Merely
Going by the affidavit, it is clear.
Lordship,
Affidavit was updated 16th of August.
that a complaint petition, Lordship,
Yes.
22nd of August,
Yes.
Lordship. And moreover, Lordship,
The complaint petition.
Lordship, another ground was taken that there is no prima facie case. But Lordship, already there is a prima facie case. They have admitted that they have borrowed some amount, 6,60,000, Lordship. And that was an admitted case. So for my understanding, Lordship, the learned additional session judge has stated that as there is an admitted position, 6 lakhs was taken. So 20% is now they are required to pay. That is already the finding is there, Lordship. Page 71, your Lordship, kindly see. Thus, from the settled law, it is crystal clear that even a security check, if dishonored on presentation, their stand is that is a security check, Lordship, would affect offence under section 138 of NI Act if the amount mentioned therein has fallen due on the date presentation. In the instant case, in the agreement dated 18/7/2021, it is categorically agreed between the parties that the respondents would repay the borrowed amount of rupees 15 lakhs within 3 months of said agreement. Undisputedly, 3 months had already expired and rupees 15 lakhs has not been paid. Thus, petitioner is entitled to encash the security checks, and in case of dishonor of said security checks, section 138 of NI Act would be attracted. The reason cited by learned trial court that respondents have taken a plausible defense during the stage of the offence explanation that they had borrowed an amount of rupees 6 lakhs. So that is an admitted case, Lordship, and not rupees 15 lakhs from petitioner, and out of that rupees 1,40,000 have already been returned, is perverse to the record, is misplaced and misconstrued by the learned trial court. At the outset, it is relevant to mention that the respondent have claimed that they borrowed rupees 6,60,000 and not rupees 6 lakhs as stated in the impugned order. Be that as it may, the fact remains that during cross-examination of PW1, no suggestion was put by the respondents to PW1 about existence of any instrument agreement which could show borrowing of rupees 6,60,000. Also, no suggestion was put to bring on record as to by which mode and when said rupees 1,40,000 was paid. This court is of the view that merely claiming that respondent have borrowed only rupees 6,60,000 or they have repaid rupees 1,40,000 without giving any more particulars does not make out any plausible defense, more particularly when there is written agreement suggesting a different view story. In said agreement, it is categorically stated that respondents have borrowed rupees 15 lakhs from petitioner. One money received to this effect.
Madam, you say you come to the first point, that is the period of limitation.
Lordship. And moreover, Lordship, the learned additional session judge has held in paragraph 20 that I do not deem it fit. Page 74, your Lordship, kindly see. To remand the
There.
Lordship.
You say.
As this is an admitted amount, Lordship, this 6 lakhs is admitted.
Whether the court can take cognizance beyond the period of limitation.
That order
Answer
was,
will cleanse the issue.
Lordship.
When the complaint was filed,
The 16th of August.
16th of August.
Yes,
And what is the period of limitation?
10th of August.
10th of August.
Yes, Lordship.
So how do you explain this?
Lordship, they have stated in their, oh, sorry, Lordship, sorry. Lordship.
As per this affidavit, Lordship, it is shows that 22nd August, Lordship.
Exactly.
Pardon?
22nd, no?
Page number 25?
Not 22nd.
Page number 26.
16th. Is number 25.
25.
Yes.
16th of August, Lordship.
Is number 5.
Lordship, kindly see this application has been filed, first page, Lordship, an application under section 528 of BNSS as amended up to date for quashing of the judgment and order dated 18/6/2025, Lordship.
No, that's all right.
Only on the prayer of interim compensation, Lordship. Not
No,
the
that's all
entire
right.
proceeding,
Regarding
Lordship.
this prima facie case.
Lordship, they have not prayed for quashing of the entire proceeding, Lordship.
That's all right.
Lordship.
But the Lordite trial court has set aside, no, sorry, divisional court has set aside the order of the trial court.
Yes, Lordship. That is on a petition filed by us under 143A, praying for interim compensation.
There you have to demonstrate the prima facie case. If your case is filed beyond the period of limitation, can there be a prima facie case?
But it is an admitted case that they have taken some amount, Lordship.
No,
They
that
have
is a
admitted,
different
so
matter.
it proves that there is a prima facie
But
case.
what about limitation? Delay of 7 days. And 2 days have been explained and condoned.
Yes.
Remaining 5 days.
5 days, Lordship, yes.
Lordship, then Lordship may fix on Monday. I will satisfy your Lordship on that point.
Okay. One more little submission, Lordship. If the 6 lakhs is admitted and the impugned order is passed that on the basis of 6 lakhs, that he has, the accused has admitted 6 lakhs, so 20% is below 6 lakhs. Then the enforceable debt, the check amount is not maintainable. Check amount is 15 lakhs. The instrument is not maintainable. If it is finding of the learned honorable sessions as that 6 lakhs is taken, 20% is below 6 lakhs, so the 20% is allowed. Then the instrument check itself not maintainable. It is 15 lakhs. 15 lakhs. They have fill up the check 15 lakhs.
Okay, let her explain on next.
Lordship.
Sir, your name, please?
There was a written agreement, Lordship. It says that
Islam.
it was for 15 lakhs, Lordship.
Assisted by Miss
M. Bordoloi, Lordship. M. Bordoloi.
Respondent, 13th part is the matter on Monday or Tuesday?
Tuesday, Lordship.
Sorry?
Tuesday, Lordship.
Okay, Tuesday.
Tuesday.
For further consideration.
Lordship, Thursday, Lordship says on Tuesday, I have some CBI cases for cross examination.
Thursday may not be possible.
Any other letter dated, Lordship, because the lower
On
court date,
Wednesday, Lordship. Then
lower court date is
Wednesday and Thursday not possible because
Friday,
one
Lordship.
pending matter is there.
Lordship. Then Friday, your Lordship. Convenient to your Lordship. Next Friday, Lordship.
oh,
Monday date.
Obliged, Lordship.
Hello.
May it be pleases your lordship. Your lordship, one matter is from legal counsel, your lordship. I'm appearing representing as legal. Your lordship, my throat is, your lordship, soaring very badly, your lordship. When the matter is called on at 1 p.m., your lordship, I'm not able to appear, your lordship. So, your lordship, one date may be given, your lordship, on Tuesday.
Mention the matter. Or day after.
Your lordship, on Tuesday, your lordship, I will not able to do it tomorrow, your lordship. Service we have taken, your lordship.
Little more serious, na?
Your lordship.
On the previous day also you remain absent. Today also you remain
Your lordship,
absent.
that was your lordship, DB is there, your lordship, thereafter, your lordship, noon, I was sitting, your lordship. So, your lordship, it was not my, your lordship.
Okay.
On date. Your lordship, Tuesday, your lordship. I'm deeply obliged.
May I please, your lordship? Lordship, this present criminal revision petition fell under section 528, relative section 438 and 442 of BNSS, your lordship. And report was called for, your lordship, for quashing of impound order dated 13/7/2020.
Lordship, GMA report has come. Can it be on Monday, my lord? We'll go through it, or tomorrow.
Why? You
Gone
would not
through
go
it.
through the same.
Lordship.
Lordship, the vehicle is the only
Okay, on
one.
Monday then.
No.
Or, Mr. SI account.
Lordship.
Alternate counsel to the. So the.
Why na silo po yes, no?
সুন্দর সুন্দর ভাই কভার করে করে দিলে ভালো ছিল।
The matter is the third to be on Monday.
Minor.
At 2 p.m.
Lordship, deeply obliged.
Item 26.
So this is my application for the mobile phone and a Aadhaar card. The report was being called.
Report has come, my lord. Charge sheet has been filed. That sir, the seized mobile phone is not further required as the case has already been submitted charge sheet before this honorable court. Or should we kindly have a look?
So we can release it.
My lord, may I kindly have a look? I'm sorry, I don't have a copy. Among the subbies, no? Scan PCR. Oh, I think. Attached to this message. 27. Did it? 27 PCR I said, was listed before night. 9.
Oh, whether during trial it will not be required.
Lordship, that is the report which we have got, no?
No, report says that so far investigation is concerned, it is not required.
My lord.
But during trial,
Okay, Panchal, it may be required, your lordship, but the IO is saying so, my lord. Panchal. File amount ako লাগিব. Wala nalagay ko. Nalagay বুলি কৈছে। Can a detailed report be called for, my lord? Detailed report
From
from the concerned OC?
what purpose will be served?
No, your lordship, they said because charge sheet has been submitted, so it's not required. As your lordship query, whether it will be required in the during trial or not, that answer hasn't come.
That's also one thing. We remand the matter to the trial court. Trial court will consider it.
Your lordship, grant the same, your lordship, because as the Sundar Lal Desai matter, it has been said that condition may be imposed there.
No.
Lana trial court will do so.
The mobile phone contains some explicit videos.
Yes.
So if we release you, you can release the same in the social media.
Matter will be remanded back.
Part Mr. S. Ahmed, Learned Counsel for the Petitioner. Additional people comes into the assisted by Ms. Learned Counsel for the respondent.
Injury about.
In this petition under section 438 and 442, read with section 528 of the BNSS 2023. The petitioner has challenged the order dated 26/5/2026 passed by the learned special judge Governor Romia in connection with Kamalpur case number 35 of 2026 under section 319 stroke 65 Wicket 1. Stroke 51 of the BNS related section 4 of the POCSO Act. It is to be noted here that by the impugn order dated 26/5/2026, the learned special judge Sonia has rejected the petition filed by the petitioner seeking custody of the seized mobile phone, certificate 1 plus 256 GB plus 12 GB, credit number 7022815832 and the Aadhaar card of the petitioner. Aadhaar card may be released.
My lord. Let the trial court decide the entire issue and pass appropriate order.
That the court may decide whether it is required for trial or not.
It is also to be noted here that while order dated for 6/2026. The learned additional PP was directed to obtain one report from the concerned IO regarding the status of investigation of the case. Today, Ms. Korea learned additional PP has produced the report of the IO. Dated 12/8/2026, and perusal of the same indicates that after completion of investigation, the IO made search sheet number 34 of 2026. Dated 19/6/2026. And it is stated in the said report that mobile phone is not further required, as the case has already been searched and now pending before the trial court. After hearing learned counsel for both the parties and also considering the report submitted by the IO, And also considering the facts and circumstances on the record, it is provided that the Aadhaar card seized from the petitioner hearing shall be released on his executing a bond that he will produce the same before the learned trial court as and when required, as and when directed. And so far the mobile phone is concerned, it appears from the documents license record that it contains some videos. Some objectionable videos, and if the same is released in favor of the petitioner, he may release the videos. And he may upload the videos in the social media. And in that way of the matter, is of the view that the petitioner may be granted liberty to approach the trial court, and the trial court will examine as to whether the mobile phone will be required during trial. And therefore to pass necessary order on the petition filed by the petitioner in terms of this revision petitions.
This matter records were called for, Lordship. Regarding that seized articles. Which is in the page number 25.
This year has not been received. Art Mr. Sona Ladet Council for the petitioner. We have additional
Recording.
of this dated 11/8/2026.
27.
That state copy of the DCR has not been received. This is a issue urgent reminder to the learned trial court for transmitting the state copy of the record. This is a list the matter on 26 August.
Yes, my lord, I have taken instruction that they are presently staying at Borakbeli, my lord.
Pardon?
My petitioners are presently staying at Borakbeli, Karimganj district, Tribhumi.
My lord, so far as my instruction is concerned, out of the three petitioners, my lord, one, my lord, is staying in Tuensang with his brother, and they are doing business of collecting agorots from Nagaland area. And number two is doing, these are being cooked and processed in their mother district, home district, Karimganj. He also used to go sometime to Nagaland. Two, my lord. And one is, three is, my lord, in Dimapur, my lord. Now, petitioner number one is one and two is doing business of agorot, my lord. So they are collecting the agorots from Nagaland, Assam, from forest areas, my lord.
No, we are not concerned with their business.
No, and for this connection, my lord, the Mustafa is staying with his brother who is staying in Tuensang itself, the town. The brother is staying there. I have mentioned in my affidavit, my lord, by meeting a local lady, my lord. He is staying there.
So your Mr. Professor,
Lordship.
Your
My
previous to
client is
transfer
my
the
lord,
case.
client is given instruction or not in any district nearby, and they have no problem, my lord. If it is transferred to any district nearby, they will.
Then let it be in Junegoto.
My
Yes,
lord, one thing I have seen, my lord, subject to your lordships, my lord, and opinion, my lord, Kifire district is the second nearest, my lord. Kifire district, Kifire, my lord, is the second nearest, around 65-70 kilometer. And from the place of occurrence, Tuensang is also 55-58 kilometer. And Kifire district is also 65-70 kilometers.
Yes,
My,
madam.
my lord, Leonard.
Lordship, this thing, what he
No.
said is correct. Like they can choose either Tuensang district or else Kipire district.
Yes,
Tuensang or Kifere?
Yes.
Kifire, my lord.
No, where it is pending now?
Tuensang.
Tuensang.
Place of occurrence, my lord, is around 55 to 60 kilometer from the, my lord, from the Tuensang.
From Shamato to Tuensang, the main point. It
Pla-
is somewhere around 55 to 56 kilometers.
My lord, likely, my lord. My lord, Samatur is the place of occurrence, my lord.
No, whether the courts are there in Kifre.
Yes, my lord.
Yes.
I have checked, my lord, online, my lord. There is one CGM and one is session judge, my lord. Only these two.
Okay, then Kifre. Dispose of the bill.
Well, my lord, one thing, my lord, I have filed an IA in this matter.
already disclosed.
And IA, my lord, in this matter.
IA is for
IA for, my lord, perjury, my lord, action, my lord. Seriously, they have misled and misgoverned from all through, my lord.
perjury. The
My lord,
cognizance has to be taken. You go to the trial court, file an application there.
My lord, kindly, my lord, 1 minute, my lord, just shortly, my lord.
No, this court cannot take cognizance of the perjury.
My lord, perhaps
Perjury
can.
is committed where?
Here in this court, my lord. Report is not court, that's why.
How?
Exactly, my lord. What happened, my lord? Kindly, my lord, come to take the kindly petition part first, my lord. Kindly pay, to come to paragraph 3 of the main petition, my lord. Main petition, my lord, that is 21.
That is the affidavit.
No, my lord, kindly come the main petition, my lord. Main petition, my petition, 21, my lord. No, 21, I'm talking about the, not about, yes, this one.
Yes, 21 is the affidavit.
No, my lord, I'm, my lord, submitting about, which synopsis, this is the main petition, my lord. Paragraph 3, my lord. Page 5, my lord. Main petition, my lord. Transfer petition. Transfer petition, criminal number 21 of 2022, my lord. It started with synopsis, my lord. First page, my lord.
Yes.
Kindly turn to page 3, paragraph 3, my lord, and page 5, my lord.
Yes.
My lord, kindly see the, my lord, the petitioners beg to state that both the complainant and the accused persons are cousin brothers, which is absolutely incorrect. Then, my lord, the next line, my lord, after the full stop, the complainant demanded some portions of land belonging to the petitioners thereof for his own purpose, as the petitioners have refused to share the said vacant positions of land with the complainant respondent number 1 thereof. A meeting has been convened in the village at Badorpur, wherein both the family members of the petitioners and complainant respondent number 1 were present, and a verbal agreement has taken place to pay some amount of money to the complainant respondent number 1. As the petitioners could not give the complainant the agreed amount due to their extreme financial crisis, the complainant, in order to harass the petitioners, have lodged an FIR in the Samatur police station at Tuensang, Nagaland. The said case was registered. Samatur, subsequently, the said PS case has been registered GR case number so and so. In the GR case, the Nagaland police, after closing investigation, has submitted a final report. Basing on the final report submitted, the Nagaland police, GR case number so and so has been disposed of by the London Judicial Magistrate First Class. My lord, that's okay. That part is, my lord. Thereafter, my lord, kindly turn to page, my lord, 9, my lord. That the petitioners, paragraph 6, my lord, the petitioners beg to state that had there been violation of any agreement by the petitioners, the complainant ought to have been instituted a money suit or any other appropriate suit against the petitioners within the period of limitation. They are saying it is a civil matter, my lord, and there was an agreement regarding purchase of land matters, my lord. And what they are doing, there are 7 brothers, my lord. They are now proceeded on the basis of that statement. They are trying to grab my land now. So much I am harassed, my lord. My lord, that's why I wanted to, my lord, even go for amicus settlement, but they did not agree, my lord. My lord, main point remain. Kindly, my lord, 1 minute, my lord. Kindly, my lord.
No. We are granting you liberty to raise the issue before the trial court.
My lord,
To go and raise the issue before the trial court.
no, my lord, this cannot be there, my lord. If
You obtain
my lord, they have committed it
and
here.
what is there?
My lord, they have committed before your lordship here, my lord.
Sorry.
My lord, it is committed before the High Court, my lord.
43.
There it cannot be raised, my lord.
Sorry.
What is it? Obliged, my lord.
Something?
This side is not there.
You are the appellant here.
I'm the appellant. I'm on a very limited point, Lordship, in this case.
That's all right, but the other side,
Evidence side is not there.
let it be on some other date.
Any day.
Or establish something not at rest. None appears for the respondent. Place the matter. 8th of September.
Obliged.
45.
I will.
Every year. Your Lordship was referring to the judgment of the apex court, Your Lordship. More present judgment, Your Lordship. Your Lordship have.
Yes, some parameters have been laid down there.
Yes, Your Lordship. Your Lordship, we turn to page. Your Lordship, turn to page.
Oh, are you furnishing a copy of the same to the court?
Your Lordship, I'll give you this. Your Lordship, just. I'll give you. Let me see. Huh? Copy as an extra. Your Lordship. I'm going to para 7, Your Lordship, see?
Purva, do you have a copy?
Yes, ma'am.
Paragraph 7.
Before delving into the facts of the case, it is pertinent to reproduce the settlement position of dealing with the validity of the execution of the will, Your Lordship. Section 60. Execution of an unprivileged will. Every testator not being a soldier employed in a.
No, Mr. Sodori.
Yes, Your
Here
Lordship.
the will is privileged or under unprivileged will.
It's a,
In the present case.
yes, sir. Unprivileged, huh? It was an unprivileged will, Your Lordship.
Unprivileged.
Unprivileged. Element, so that the testator shall sign or shall affix his mark in the will, or it shall be signed by some other person in presence by his direction. This is very important. This is explained in the will, Your Lordship. The signature of the mark of the test, I'll show it from the will also later on, Your Lordship. And the signature or the mark of the testator or signature of the person signing for him shall be so placed that it shall appear that it was intended thereby to give effect to writing of will. This is also not there, Your Lordship. Then the will shall be attested by 2 or more witnesses, each of whom has seen the testator sign or affix his mark to the will, or has seen some other person sign the will in the presence and by direction of the testator, or has received from the testator a personal acknowledgement of the signature or mark or signature of such other person, and each of the witnesses has signed the will in presence of the testator, but it shall not be necessary for more than one witness to be present at the same time, no other person. Your Lordship, here I am posing a moment. Here, according to them, the testator wife was with them when he went with the will, Your Lordship, to get the signature and all these people. But the wife has challenged the will itself. It's a forgery, Your Lordship. And where even if she was present, she was not made a witness, Your Lordship. That shows cast doubt on the will, Your Lordship. So they have. I'll show it from the deposition itself. Those things are stated. Then section 68 of the Evidence Act, Your Lordship. Proof of execution of document required by law to be attested. If a document is required in law to be attested, it shall not be used until one attesting at least one call for the purpose of proving it, if there is one alive subject to process. Here, Your Lordship, attesting with a side, merely putting a signature and putting the signature and attesting are two different aspects, Your Lordship. Here, they say they have put the signature only. They have asked to put the signature. That is their statement, Your Lordship. Then, if Your Lordship will come to para 10, where they have referred to the various judgment of apex court, Your Lordship. Relying on this judgment, Your Lordship says this thing, we can deduce the following principles required. These are important, Your Lordship. The court has to consider two aspects. First, that a will is executed by the testator, and secondly, that it is the last will executed by him. 2, it is not required to be proved with mathematical accuracy, but test of satisfaction of the prudent mind has to be applied. Then third, a will is required to fulfill all the formalities required in section 63 of the section. All formalities has to fulfill, Your Lordship. Then it says the testator shall sign or affix his mark on the will, or it shall be signed by some other person in his presence and by his direction until the said signature and affixation shall show that it was intended to give effect to the writing of the will. This is absent here, Your Lordship. Then it is mandatory to get it attested by 2 more witnesses, though no particular form of attestation is necessary. Then see, each of the attesting witness must have seen the testator sign or affix his mark on the will, or has seen some other person sign the will in the presence and by direction of the testator, or has received from the testator personal acknowledgement of the signatures. Then nothing is there, Your Lordship. Each of the attesting shall sign the will in presence of the testator. However, the presence of all the witnesses at the same time is not required. Then 4, for the purpose of proving the execution of it, at least one of the attesting witness who is alive, subject to process of the court and capable of giving evidence shall be examined. Then 5 is the attesting witness should speak not only about the testator's signature, this is very important, but also that each of the witnesses has signed the will in the presence of the testator. If one of the attesting can prove the execution of the will, the examination of other witness can be dispensed with. When one attesting witness examined to prove the will fails to prove its execution, then the other available has to be called to supplement his evidence. Whenever there exists any suspicion, this is important, or to the execution, it is a responsibility of the proponder to remove all legitimate suspicion before it can be accepted tested last will. In such case, the initial on the proponder became here, Your Lordship is that it was a case of that testator was suffering from Parkinson disease. So Parkinson disease, if Your Lordship see, he doesn't have free mind of things. Parkinson disease, he doesn't have, and that has been admitted by them that he was suffering from Parkinson disease. This is admitted by them for Parkinson. A person with a Parkinson disease cannot have a free will or something to execute a will, Your Lordship. Parkinson, because he is not in a normal state of mind. That I have given the literature on Parkinson on the last occasion, Your Lordship. So Parkinson, you cannot. That doubt has it is burden on them to dispel the thing that has not been able to. Because if the person, they have to show that he is a free mind to execute and he is capacitated to execute the will. That has not been shown, Your Lordship. Not been in evidence also. Then, if Your Lordship, the test of judicial conscience has to be evolved for dealing with those cases where execution of will is surrounded by suspicious circumstances. Here it is though. It requires to consider factors such as awareness of the testator as to the content of the will. It is very important, Your Lordship. As consider nature and effect of disposition of the will, sound, certain disposing state of mind, and memory of the testator at the time of execution. Testator executed the will while acting on his free will. This is very important. Then one who alleged fraud, fabrication, undue influence, or etc. has to prove the same. However, even in the absence of such allegation, this is important. If there is circumstance give rise of doubt, then it becomes their duty on the proponder to dispel such suspicious by giving cognizant consent. This is important. Second part. Because suspicion is there and they have to dispel the suspicion. Then suspicious circumstance must be real, genuine, and valid, and not merely a fantasy of doubling the mind. Whether a particular feature would qualify as suspicious would depend on the facts and circumstances of each case. Any circumstance raising suspicion legitimate in nature would qualify as suspicious. For example, a shaky signature, a feeble mind, it is important, an unfair and undisputed disposition of property, the propounder himself taking the leading part on making of the will, under which he receives substantial benefit. This is so, Your Lordship. He is getting a substantial benefit of the thing. The entire land has been taken off, Your Lordship. In short, apart from the statutory cover, broadly it has been proved that the testator signed out of his own free will. This is very important. At the time of execution, he is in a sound state of will. This is also very important. He was aware of the nature of the fact of the will, and the will was not under suspicion. All these conditions are, Your Lordship, not there, Your Lordship, in the present case. Coming to the facts of the case, a careful arrangement matter so and so, Your Lordship, this preponder has. So these are the principles laid down by the judges. So now Your Lordship, I take Your Lordship to the will itself. Page number 52, Your Lordship. Your Lordship say. My Lord has got it. This last will and testament Sri Muninder Chandra Barua, so and so, resident of Hatigarh, so is made on 11 June 2009. This is written by hand. Everything is typed. This is written by hand. At Gauhati in sound mind and sound health, without any undue influence and coercion from anywhere. By this will, the Sri Mahendra Chandra execution of the will bequeath his movable, immovable property in the following manner after his death. Then immovable property, if Your Lordship will see, just the appellant, that land owned by Hatigarh Sari so and so, measuring 2 kathas and bearing patta number so and so, Moza Bella and Pradeep Kumar Bhattacharya so, and sold as the sole legatee there, sole legatee, he said. That he'll look after land and boundary walls on other apartment works required for good maintenance of the compound and will pay land revenues and everything. He will defend the interests of the land at court. He'll allow free access to inmates on the ground floor as well to Assam tribe on the roof of the first floor without any ladder heater. Further, he'll allow existing space of garage for the use of inmates of the ground floor for the first floor. In other words, he'll give all the facilities, utilities available municipal at the time. Here, if Your Lordship will see, some of the things are present thing when he's alive. In other words, he will give all facilities available to Muninder Chandra till the time of his death. The existing water tank and ring well shall be allowed to be used by all of us and practice center. The ground floor of the house or said land bearing Gauhati municipal ward number is bequeathed to my wife, Srimati Mirani Bora, as a sole legatee. She has contested the will. She's no more, of course. She's no more now. Savita Das. Savita Sharma has come in her place. Gauhati municipal so and so, bequeathed to his wife Mirani as a sole. The roof of the ground floor was already given to lease to my nephew. That about a period of 19 years. Lease did bearing. This has not been exhibited at all. No lease did exhibited by them also before the court. This will shall further empower him to hand his heir to assign to be the absolute after the expiry of the period of 99 years of the said by virtue of this will. Sri Pradeep Kumar has already constructed house on the roof of the ground floor at his expense and which is covered by the holding 1680 ward number. There are handwritten, Your Lordship. The Assam type house on the roof of the first floor bearing Gauhati municipal ward number now occupied by Barun Chandra Burman, free of rent. Yeah, Barun Chandra was PW4 also, Your Lordship. I'll take his evidence also later on. Free of rent shall continue to be occupied by him and he is assigned as before, after marriage, he will have to pay the cost of electric charge and water supply. He'll be entitled to make minor repairs, so and so, your lordship. It is needless to say that Barun Chandrav ensures good behavior for maintenance of peace and tranquility with the occupants on ground floor, first floor, and second floor. The 1/5 of the 1/5 ancestral joint paper of the tea land owned by the Munindra of the tea state Hatigarh, Jorhat, bearing tea board number 7 is vacated to Srimati Milaniva. Then 6 is very important. In case my wife Mrinani Bora dies within 6 months of my death and without making any will, in such an event, a committee consists of, this is very important, Anshuman Bhattacharya, son of Pradeep Kaur Bhattacharya, and Dr. Lucky, daughter of so and so, shall decide to find out suitable person among the descendants of will be the last person to inherit the ground floor, so and so, whatever. So, your lordship, will cannot have such conditions. Will cannot have such a condition. After, if someone happens, will you bequeath the property unconditionally? It's not that if you something then you will get a this right also that since the property has been bequeathed by the will, it cannot be a conditional thing. Then your lordship, he has referred to movable property, your lordship here, the bank account and everything. And your lordship will see here, there is no schedule of immovable property, your lordship. Now, I'll take your lordship to the petition, your lordship. Your lordship will see this, page 56. 56, attested witness, if your lordship will see. Nothing is said. Page 56, if your lordship, there's a sign as witness. There's no statement from the witness that attested has signed in their presence, and thereafter the attested had put their signature to the will of the power. They have not nothing. This sentence is totally missing, your lordship. It should have been there in the will. Just as put the signature, your lordship. No attestation is attesting witness is not there, your lordship. This cannot be termed as attesting witness. Because I'll show you from the deposition also there, that will come out from here. Now I take your lordship to that petition, your lordship. Petition which they filed, your lordship. Here, if your lordship will see probate case, here, if your lordship will see page 48. Your lordship, I will point out one thing. Probate case cannot be done in part of the portion of the will. It has to be done, probate case has done with the entire property. It cannot be done in piece. I take this portion, someone will take other. That's not like that. Here, if your lordship will say schedule of the property is here. Page 48. Here, for the first time, the schedule has come. No will, there is no schedule. A plot of land measuring 2 kotha covered by dark number patta situated revenue. My lord has got page 48. Under Moja Beltra in the district of Kamru, Assam, so the first floor measuring 1400. These are bounded by these things. These are not there. Then list of witness. He has put a list of witness here again. These are the Satyabhata Borua and so witness in the schedule also. No, Satyabhata Borua is brother-in-law of Acha. Proponder. So your lordship will see here, although in the will he is claiming some movable property of here is nothing is there. In the will, according to will, he some movable property is also with him. But in the will, then if your lordship, I'll take his deposition again. As evidence, if your lordship PW1, the appellant, your lordship, if your lordship turns to page here, your lordship. Yeah. Yes, yes. No, cross. Your lordship will see page 66. Page 66. These are the facts newly added. It's not the probate petition. Page 66. If your lordship will say immovable properties, land owned by late so and so 2 kothas. Moja has been bequeathed to my and nephew of the tester late Munir, subject to certain embodied in the will dated so and so, and exhibit 2. The presence of further it is to depose the dark number and the patta number of aforesaid plot number has changed, which is so and so. Then here comes Schedule A. There is no Schedule A in the ideas. Schedule A, he gives the plot of land. Then if your lordship will see Schedule A, he gives a list. Their schedule is only one. A plot of land measuring 2 kothas so and so. He is given a boundary. Then ground floor of the house of Schedule A bearing Gauhati Mitzvah so and so has been bequeathed to Milani but defended in the present suit, tested at so and so. As the roof below the ground floor, so he is giving all these statements for the district. These are not part of the probate petition. Then ancestral power, he is claiming all those things. ancestral property joint, this has not been claimed. Serial number E, if your lordship, page 67. This is not a part of the probate petition. 1/5 of ancestral T property owned by testator and the T estate has so and so. This has not been claimed in the probate petition, your lordship. Then comes movable properties. This is not there in the property for 68 to this thing, your lordship. So this is not there, your lordship. So then he made a statement at para 11, page 70, if your lordship see, that in view of the facts I am entitled to grant probate. I am entitled for grant of in respect immovable and movable property, right? Muniro, so and so, so and so. Therefore, here, your lordship, in the probate period, he is claiming only immovable property. If your lordship see the prayer there. Just your lordship. In the probate page 47, your lordship, prayer. My lord has got it.
Only in respect of the.
Your lordship, only schedule, early the schedule. If your lordship will see schedule 48, 47 is a prayer. Yes, your lord. If page 47, if your lordship will kindly see. It is therefore prayed, page 41. It is therefore prayed that, my lord has got it, page 47. Page 47, my lord. May I read, your lordship?
Yes.
If you are para 10, it is therefore prayed that your honor will be kind enough to please grant and issue probate in favor of petitioner Pradeep Kumar Bhattacharya for the entire property. Entire property, here entire property of the houses described in the entire property is not given to him, your lordship. Described the which was bequeathed by the executor Munisa in order to administer mutually divide partitions between the parties. So here he's talking about this schedule only. Entire, he is claiming entire land here and the first floor. There he is claiming that these are the shares of other people. So, your lordship, then here, then your lordship, this is this because schedule is totally different. Here is praying something and evidence, I mean, he is extending the everything. These are not there everywhere. Huh? Huh?
But Mr. Chaudhary, those properties are mentioned in the will.
Will, but in a probate, nothing has been mentioned. Probate petition. He is claiming only a schedule of land. And evidence he brought everything there. He cannot do that. He is claiming only a schedule, immovable property, your lordship. And I pointed your lordship that probate cannot be, the will cannot be probated in part. It has to be done in a whole. It is not that I take 1%, the other person comes, he file a probate, he takes the other. It's not like that. Then there will be conflict of interest may be there. So that's not the proper procedure, your lordship. That's why that probate was rejected by that trial court, your lordship. Huh? Your lordship, section 281 of the Succession Act is very important. Verification of petition of probate by one witness. Where an application is for probate, the petition shall be verified by at least one of the witnesses and will procure in the matter of favor. Namely, ICD, this is important. Oh, sorry, I'm sorry. Section 281 of the Indian Succession Act.
Yes. Verification.
Where the application for is for probate, the petition shall be verified by at least one of the witnesses to the will when procurable in the manner and to effect the following manner. ICD, one of the witness of the last will and testament of the testator mentioned in the above petition, declare that I was present and saw the said affix his signature or mark thereto, or that the said acknowledge the writing annexed by the above petition to his will testament in my presence. This is not there, your lordship, at all. There's total absence of
Verification is not there.
Not there, your lordship. Because I'll show it on the deposition also, Your Lordship, it is not there,
Not there. It is admitted, it is not there.
it is not there, Your Lordship. Then if Your Lordship will see the evidence also,
Is this provision mandatory?
yes, Your Lordship. This is mandatory, how, because this, other, how can the will be, because if you see the judgment, that is categorically stated. Supreme Court judgment, Your Lordship, this has to be there, this condition is one of the conditions.
Also be verified. Cell
Yes.
is there.
Yes, cell is there.
But I have some decisions, my lord. The absence of this verification is not fatal to the probate application, my lord. Absence of a verification by attesting witness.
But while the section itself says that it
Yes.
is mandatory, then
And the Supreme Court judgment is also saying that.
I have citation, but not right in my position, my lord. But I have the judgment, my lord.
you have the judgment.
Yes, my lord.
Okay, produce it, we will see it.
Yes. Approximately. But my lord, my submission is there. In the trial court, my lord, their main objection is two part, my lord. First, they say the will is forced and manufactured. And second one is that the testator is suffering from some illness, my lord. But they refused to adduce any evidence in the trial court. This on record. They refused. They did not adduce any evidence, my lord. Secondly, my lord, the trial court rejected my probate application on three grounds, my lord, broadly. First, because of absence of the evidence of the scriber of the will, my lord. Because as per the trial court, my lord, the person who write the will, my lord, his evidence is absent, my lord. That's why the trial court hold that the timing and drafting of the will has not been proved by me, my lord. And second ground is that, my lord, I have not adduced evidence of the close relatives and family members of the testator, my lord. And third one is that the two attesting witness, they did not inform the family members of the testator that there is some existence of a will. Only these three grounds, my lord, the trial court rejected my application, my lord. And these grounds they have adduced here is a fresh ground, my lord. They did not adduce these grounds on the trial court, my lord.
These are the
Their
record.
main two objection is there that will is a forced and manufactured, and second thing is he is suffering from paralysis, my lord.
No, they can, on law point, they can raise the ground.
These are all
That
legally.
is one part.
Supposing this 281,
Huh.
verification is not there.
Yes,
They can take such a play in this appeal also.
yes, my lord.
Is there any bar?
No bar, my lord. No
On
bar,
law
my lord.
point, they can.
Law point they can. But they did not adduce any evidence in the trial court.
Maybe on law point, they can argue.
Yes. But regarding the forced and manufactured will and their illness, my lord, they have raised the objections, but they did not adduce any evidence. In fact, they refused to adduce.
But
any
they have
evidence, my
admitted
lord.
Parkinson disease.
No, my lord.
Yes, it's there.
No.
In the position. The position is there. I show you just now. In cross page. Page 88, PW1 statement. It is a fact that Munin Chandra was suffering from Parkinson nephrosis disease. He has admitted this fact. Page 88, you will see. Is the petty appellants in cross he has admitted. I do not know what the effect of Parkinson nephrosis is. I don't know who drafted the. He doesn't know who drafted the executive will also.
Yes, my lord.
I did not read the will and I do not know who has prepared the.
No,
I do
my
have to
lord.
wait. See here, he has
89,
admitted
my
Parkinson
lord.
disease, your lordship.
Page number 89, my lord. First paragraph. It is not a fact. Starting from it is not a fact. That in the year 2009, in this year, my lord, the will is prepared, my lord. Munin Chandra Borua was suffering from ailments, my lord. It is not a fact. It was put to the witness that whether he is suffering from any ailment in the year 2009, but the witness refused. Later on, my lord, what they are suggesting, my lord, it is a fact that Munin Chandra Borua was suffering from Parkinson and nephropathy diseases. The question is that on the later part in the year 2018-19, my lord, he is suffering from these diseases. But in the year 2009, Munin Chandra Borua was not suffering from any ailments, my lord. It is specifically stated by the witnesses, my lord. Page 89.
Your lordship, what will happen if they have admitted this fact? They have to show that it was not there in 2000. If they have not admitted that fact, that burden was on us. But they have admitted he is suffering from, but he has to prove that he was not suffering from Parkinson in 2009. That he has not proved.
How can I prove, my lord? In 2009, I am
That-
saying that he was not suffering from any ailments, my lord.
Okay,
Because it is
but-
their objection, my lord, that he is suffering from Parkinson disease. Burden on him to produce any medical documents that in the year 2009, I am suffering from any disease, my lord. Because I am saying that in 2009, I am not. suffering
And
from
the
any kind of-
wife has categorically said there's no will. Wife, they said wife was present with the husband testator when he suffered. But she was not taken as a witness or no, and she has claimed this will was not executed by her husband. They have taken blank signature and done it in plain paper. That is the
assertion,
case.
my lord.
That is the case there. Your
They
Lordship.
did not adduce any.
What there is
supporting material,
question
my
is
lord.
that is when you have admitted she was there and you have not taken her, and she has filed a case that this will is not a genuine document. They say that. So the question, the burden shifts on you. Because you are saying she was present, the wife was present, the testator was according to you, the testator and the wife came to your brother-in-law's place to get the document signed. And yeah, they signed it. They have not seen the document also. They signed it and went on. That is their case, Your Lordship. And she said to Your Lordship. And their evidence also saying the contrary, Your Lordship.
In respect of this section 281.
Yes, Your Lordship.
Let him produce the
Yes, sir.
11
Let it be respect.
decision. And anything you were to submit today?
I'll submit when after I get the judgment. Because otherwise it will be piecemeal also. Let him complete that, then I'll reply to that also, Your Lordship.
Okay.
Can you have it next Thursday, Your Lordship? Next Thursday. Next Thursday.
Thursday. September. Okay. September.
September.
Since part third since law.
Part third is it can come up. It's a part third matter, no?
Thursday. So one on Thursday and Wednesday, one pending matter is there.
Yes.
Part third matter.
After they will take a chance, it's no problem. After that, we have made let the matter be
So
listened to.
next week, next 2 weeks.
Next 2 weeks, you are not there, Your Lordship is not there. I know that. I've seen the roster.
Yes.
So that's why I have to finish it and go, Your Lordship, because that's why I'm claiming Thursday. Because Tuesday, if it will come down below again, the whole problem will start. List has been already prepared, no? So that's why Thursday, the list is not prepared, at least it can come up.
Thursday, mystery.
It won't take much time, I think. While
On Friday.
Friday, no
Top
problem.
of the list item.
Friday, I can do it. Friday, no problem. Friday.
The 21st.
Friday, no problem. I have no problem. Friday.
Okay. Heard Mr. Borua, learned counsel for the person. Now, for the appellant. Mr. Soduri for the respondent. Heard in part, list the matter for further consideration on Friday. As top of the list item.
Deep levels.
Obliged, ma'am.
Thank you.
Please, Your Lordship.
Yes.
Lordship, may I pray for another date in this matter? It's an appeal ready to be heard finally.
Okay.
I have gone through my.
Appeal against conviction.
Yes, Lordship. Conviction is under 376 AB, read with 511. There's also POCSO section 6, read with 18.
But the punishment is sentence is imposed under section.
376 AB, read with 511. Attempt of
27.
Obliged.